Yes.
Lordship, I beg to mention item number 10. This matter to be allowed to list next week.
Why?
Item number 10. Well, we are filing our affidavit only today.
Who is for the petitioner?
Huh?
You have
Lordship, I think we have two cause lists.
two cause lists.
All Nagaland. Petitioner is
Item 10. Item 10, WPC 108.
then my matter is all Nagaland. That is item number 11. 11. 11.
You have any objection?
Yes, Lordship. In fact, Lordship, here the interim prayer is yet to be heard, Lordship. We have to pray here, but the government has been seeking time since then, Lordship. On the several occasions, last chance has been given to the government, however, till the day to. So I pray that if the interim prayer can be heard today, Lordship.
Lordship, we have sent for waiting. We are waiting and we are expecting today. So the matter will be listed on.
Let the matter be called for.
No, it is not a lengthy one.
Lordship, it's a short matter. This
No, we'll consider when the matter is called in its turn, whether to grant you adjournment or not. After going through file, we will pass orders. You wait for your turn.
Lordship.
Yeah, please, Lordship. Lordship, I beg to mention item number 15, Lordship.
1-5. Yes.
Lordship, I pray that this matter come up after a week, Lordship. Lordship, they have filed the additional affidavit, Lordship. To that effect,
Yes, Mr.
second
Shaki.
instruction.
Yes, Lordship, I filed an additional affidavit last week. However, Lordship, no instruction may be required in the additional affidavit because it's just bringing the records.
Heard Mr. Joshua Shaki, Learned Counsel. Why are you seeking adjournment?
Lordship, since they have filed an additional affidavit, we need a certain instruction.
Okay. Also heard Mr. V. Zimumi, Learned Government Advocate, who prays for some time to seek instruction in view of the fact that the petitioner has filed additional affidavit.
Lordship.
The prayer is allowed. Let this matter be listed after 1 week.
Blush.
Well, please, Lordship. My Lord, I beg to mention item number 17. My Lord, here I'm yet to receive instruction, so kindly allow me 3 weeks' time.
You have informed the other side.
Yes, my Lord.
Heard Mr.
E.T. Papa.
E.T. Bafom, Learned Counsel for the respondent.
Respond number 5, 6, and 7.
Respondent number 5, 6, 7. Also heard Mr. Moaz Amir, Learned Counsel for the petitioner. On request of Learned Government Counsel, this matter is adjourned for a week,
3 weeks.
for 3 weeks, to enable them to seek instructions.
Yes, ma'am. Much obliged.
May it please, my Lordship, I may be allowed to make a mention for item 16. I have taken the consent of my learned friend for the opposite party. If the matter can kindly come up after a week, my Lord.
Not Mr. Saintianger, Learned Counsel for the petitioner, who prays for an adjournment. Why are you seeking adjournment?
Well, I want to file an affidavit. I will file it after tomorrow. The petitioner is coming tomorrow to Kohima.
Seek adjournment for, as the petitioner intends to file an additional affidavit.
No, my Lord, affidavit in opposition in the IA.
Okay. Affidavit in opposition in the interlocutory application. The Learned Counsel for the
For this one.
Respondent Mr. Muazzami does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed after a week.
My lord, deeply obliged. Lordship, there is an interim.
The interim order shall continue till next day.
Deeply obliged.
Please, Your Lordship, I beg to mention item number 9. Here I have just received the reply filed by the petitioner. So if I may be given a week's time to go through it, Your Lordship, let the matter come up after 1 week.
Objection.
Third, Miss A. Learned Government Council, who seeks a 1 week time to go through the
Reply filed by the
reply filed by the petitioner. Learned Council for the petitioner does not opposes the prayer. Hence same is allowed. Let this matter be listed after a week.
Lordship, I'm allowed to mention item number 6 and 7. Here in item 7, that is the WC 298 of 2023, and received a counter file by the respondents 1 to 5. So a further 1 week may be granted to file a reply.
Lordship has the last chance because the petitioner is occupying a post on the basis of land ownership. But the verification was done by the Deputy Commissioner Office, whereby it has been clearly stated that this is not a landowner. His appointment itself is illegal, Lordship, and he's occupying a post on land ownership.
Okay, let him file the
1 week, Lordship, as a last chance, Lordship,
okay.
because they have already taken time for.
Heard Mr. Supamwati Waling, Learned Counsel for the petitioner, also heard Mr. N. Muzai, Learned Counsel for
The private respondent.
the private respondent, as well as Miss S. Chang, appearing for the state respondent. Learned Counsel for the petitioner seeks a week's time to file affidavit in reply against the affidavit in opposition filed by the respondent side. The prayer is allowed. Let this matter be listed after a week.
Lordship.
So, Lordship, I may be allowed to mention from the order list, item 18, Your Lordship. Here the state is yet to file counter. So, Your Lordship, I kindly grant 3 weeks' time to file counter.
You have informed the petitioner side.
Lordship, I have seen the petitioner this morning.
You have to wait for your turn. Yes, Mr. Pongener is there. Do you have any objection?
If they have received instructions, it may be recorded.
You have received instructions. Heard Mr. T. Pongener, Learned Counsel for the petitioner. Also heard Miss Ina Holly, Learned Government Advocate.
The Lordship, for respondent number 5, if my name can be reflected in the post list.
In which item? This item.
Yes, Your Lordship.
Also heard Mr. J. Sheki, appearing for respondent number 5. Learned Government Council submits that the respondent has received, that she has received instructions and would require 3 weeks' time for filing of affidavit in opposition.
Respondent number 6, my lord, my apologies.
Joshua Sheki, respondent number 6. Learned, considering the submission, the prayer is allowed. Let this matter be listed after 3 weeks.
Please, my lord. I beg to mention item number 23 from the hearing list. If this matter may come after a week. On 19 Tuesday.
No fixed date. What is your name? I forgot.
Respondent number 4.
Mr. Aizamir, Learned Counsel for respondent number 4. Praise for an adjournment on which, what is your ground?
Lordship, today we have some personal difficulties.
On the ground of personal difficulty. Learned Mr. T. Pongene, Learned Counsel for the petitioner does not opposes the prayer. Hence the prayer is allowed. Let this matter be listed after
A week.
a week.
Lordship, there is an interim.
The interim order. After 2 weeks. After 2 weeks, the interim order shall continue till next day.
You're right. May I please, Your Lordship? Lordship, I beg to mention item number 8 of today's daily post list. Lordship, today's date is fixed for filing of Bakalat Nama as such. We'll be filing the Bakalat Nama in the course of day. As such, Your Honor may be pleased to adjourn the matter for today.
Your counsel,
I'm for the petitioner.
you have not filed Wakalatnama.
Yes,
You are newly engaged.
yes, Your Lordship.
Okay.
The previous council has withdrawn his Bakalat
What
Nama.
is your name?
K. Nagi.
Heard Mr. K. Nagi, learned counsel, who submits that he has been newly engaged by the petitioner and seeks some time for filing Wakalatnama. Also, Ms. S. Chang, learned government advocate. When will you file?
Today.
Wakalatnama during the course of the day. Stop. The prayer is allowed. Let this matter be listed
For 2 weeks. Lordship.
after 2 weeks.
Much obliged.
Mr. Lordship, I beg to mention item number 20. My lord, the service report upon respondent number 8 to 11 is still awaited, so I pray this matter may be listed after 3 weeks.
Heard Ms.
Sorry.
Soreni Mozui, learned counsel for the petitioner. We have to see the records. You have gone through the records.
Yes, my lord.
It appears from record that the service report in respect of notices issued to respondent number
8 to 11.
8 to 11 have not yet been received. Also show the presence of Mr. N. Angami, learned government counsel,
Yes.
appearing for
Respondent 1 to 7, madam.
1 to 7. Await further. Let this matter be listed after 2
3
weeks, 3 weeks.
Much obliged.
Obliged, madam.
Mr. Lordship, I beg to mention hearing item number 25. My senior is in this cause. Pending is the matter after 2 weeks.
You are for?
I'm for the petitioner.
You have informed the other side?
Yes.
Yes. What's your name?
Menashino.
Write her name. Heard Miss who learned counsel for the petitioner who prays for an adjournment on the ground that the senior conducting counsel for the petitioner is indisposed. Learned Mr. N. Angami, learned senior government counsel,
Lordship.
does not opposes the prayer. Hence, the prayer is allowed.
Lordship is an interim.
Let this matter be listed after 2 weeks. The interim order shall continue till next day.
Obliged.
Lordship, I also beg to mention item number 19.
Same ground.
No, the service report, for respondent number 4 is still awaited. I've gone through the report this morning.
Your name is Menosino.
Sanch.
Heard Miss Menosino, learned counsel for the petitioner. Also heard Mr. K.V. Angami, learned government counsel. Senior government counsel, learned senior government counsel. It appears that the service report in respect of notices issued to respondent number 4 are still awaited, is still away, has not yet been received. Await further. Let this matter be listed
3 weeks.
after 3 weeks.
Much obliged.
For motion, item numbers 1 and 2.
May I please, my lord.
Yes.
The Lord, this I is being filed with a prayer for amending the prayer clause 2 of my writ petition. Here is page 6 of my application, my lord.
Yes.
Page 6 of my application, that is paragraph 3. There I've stated that the prayer in WBC 220 of 2022 are as follows. The relevant is clause 2. To upgrade the post of senior most driver to head driver under the departments mentioned in Annexure 5A. So this application is been filed to replace the words Annexure 5A to paragraph 6, Lordship. So for that, I
Any
filed an
objection?
No objection.
Heard Mr. Supamwati Waling, learned counsel for the applicant. Also heard Ms. A. Aimi, learned government counsel. This interlocutory application has been filed by the petitioner in connection with WPC number 220 within bracket K/2022, praying for allowing the petitioner to amend the prayer portion of the writ petition. Learned counsel for the petitioner has submitted that for making the prayer more specific, the amendment sought for would be necessary. Stop. Learned government counsel does not opposes the prayer. Stop. The prayer is allowed. The petitioner shall file an amended writ petition
in the course of the day.
during the course of the day and also serve a copy of the same to the respondent side. Let this matter be listed.
On 19th.
Fixed date on 19th. Okay. On 19th.
Obliged.
For motion, item number 3.
Yes, your lordship, here the petitioner is bring for amendment of the writ petition in connection to WBC 269 of 2023. Your lordship, in the previous order, which is at page 9.
Page 9 of the
Of the I, yes, lordship. Page 9 of the I.
yes.
My lord, by this order dated, the petitioner has allowed to file an amendment application. So based on that, I'm filing this I for amendment of the writ petition, the prayer portion as well as in paragraph 9 of the writ petition, lordship.
Why amendment is required?
Lordship, at the time of filing this instant writ petition, since the impugned approval order, administrative approval order, which is annexed at page 6 of my I.
Oh,
was
you have not
readily
challenged
available.
that.
Yes, lordship.
Yes, Mr. Pote. Anything?
Next, my lord. My lord, I leave it to your order.
Heard Mr.
Tushi
Temchen, learned counsel for the petition applicant. Also heard Mr. Foseko Forte, learned counsel for
The private respondent.
the private respondent, as well as Miss S.
Number
Chang,
5.
private respondent number 5,
Yes.
as well as Miss S. Chang, learned government counsel. This interlocutory application has been filed by the petitioner in writ petition number, in connection with writ petition number 269/2023, praying for allowing the petitioner to amend the prayer portion of the writ petition as well as also to insert a new paragraph, that is paragraph 9A, whereby the 9A challenging the administrative order dated 13/1/2023 for appointment of respondent number 5. Appointment as what? Appointment for of respondent number 5.
His lordship.
As multitask worker. Stop. Learned counsel for respondents. Learned government counsel as well as private respondent. Learned counsel for state respondent as well as private respondent does not opposes the prayer. Hence the prayer is allowed. The petitioner shall file an amended writ petition when
1 week
within a week times with a copy of the same furnished to the respondent's counsel. Let this matter be listed after 2 weeks.
Lordship, in the meantime, interim will be continued.
The interim order shall continue till next day.
Right. Much obliged.
For admission, item numbers 4 and 5.
Dear this lordship,
Yes.
I believe lordship has brought the blessed waiter
Yes.
from Gauhati.
Yes.
On last occasion, that is on 6, my learned friend CJC was directed to obtain some instructions to clarify on one point. I do not know whether he has brought the instructions or not, but then if no instructions is received today, then the matter will be heard on the basis of the materials available on records.
What instructions?
That was the order passed on the last occasion. Instruction is lordship, before coming to the case, the instruction is to the effect that the selection for the MBBS seats is being allocated by the central government to the beneficiary, few selected beneficiary states. And along with that, the send instructions and guidelines in the form of letter, sometimes in the form of office memorandum. And strict instructions are given to follow while allocating the seats for MBBS studies. Now, the state government.
Lordship,
No, I am responding to the lordship query.
Let him.
Let me complete that first. Thereafter, madam.
What is the issue here?
Issue is, this is in connection with admission in MBBS course, MBBS.
Okay.
So it is a time-bound matter. Considering that urgency, the matter has been fixed today for disposal. Now, the instruction was, I'm coming to the query made by your lordship.
You were not selected.
In spite of.
You are a candidate. You are a candidate.
Yes. Instead of securing second position in the NEET merit,
Okay.
I have not been selected and ignored because
Second position in which?
NEET, National Eligibility Entrance Test, that is conducted by the government of India,
No, which merit list you were second?
state list.
So NIT prepares separate list.
Lordship, I
What?
think it would be better to start from the beginning.
Yes, that is what I am asking you.
Yes. So, before I come to the petition, broadly, the MBBS seats are allotted by the central government to few selected beneficiary states and union territories. And for this year, 9 states were selected for allocating the central pool MBBS seats by the center for the state of Nagaland. 42 seats have been allocated to the state of Nagaland. And besides that, Lordship, there are other seats like Nikrims in Shillong, about 10 seats. And then Rims, Imphal, about 10 seats. And then Nagaland have a medical college, Lordship is well aware, since 2023. It has a capacity of 100 seats, out of which 85 seats are reserved for the indigenous inhabitants of Nagaland, and 15 seats is being left as central port.
Okay.
So like that, in that manner, the seats are allocated. Here, the petitioner is claiming her seats against the 42 central pool MBBS seats allotted by the central government to the state of Nagaland for 2025-26.
This 42 seats will be in which medical colleges?
It will be allocated to different medical
throughout
colleges.
India?
Yes.
Okay.
And before that, Lordship, the government of India, they have issued guidelines how these 42 seats are to be allocated to the candidates. Not only for the state of Nagaland, though all the beneficiary states, that is 9 states.
State of Nagaland means what? It is allocated to candidates.
Seats are allocated to the state of Nagaland.
State of Nagaland means candidates belonging from state of Nagaland.
No.
Then
that is why I am coming to that. Government of India has issued an instruction. That is, the central government, central service employees posted in Nagaland, either on deputation or having their headquarters in the state of Nagaland. Children of those central employees shall be treated at par with local residents.
okay.
And the petitioner is claiming from that quota. Basing on that instructions and guidelines issued by the government of India, the petitioner is claiming her seat on the basis of the guidelines issued by the government of India. And that guideline says that the children of central service employees in the state shall be treated at par with local residents. That is the eligibility criteria. And the selection of candidates shall be done strictly on the basis of the merit list secured in NEET examination.
Okay.
So, my grievance is the government of India, who has allocated the seat, has given specific instructions to the state.
One more query.
Lordship.
When you say that 42 seats are allocated to state,
Yes.
it is allocated to states or candidates belonging from, what is the language?
For the state. And then instructions, I'm talking about the instructions. Along with allocation of the seats.
State will not
How-
take admission. Candidates will have to
Coming
take.
that. How these 42 seats are to be allocated by the state.
Huh.
That instructions is being given by the government of India in their letters or in the form of office memorandum. How it should be allotted, clear instructions are given by the government of India.
Okay.
Now, in violation of that guideline, the state government has framed a policy so as to deny those persons who are made eligible by the letter of the government of India. That is the crisis here. That is the dispute to be decided, Lordship. But before that, I'm just trying to take your Lordship to the background only to understand in a summary manner. So, the children of the central government employees shall be treated at par with local residents. That,
Central government employee posted in Nagaland.
yes, either on deputation or having their headquarters in Nagaland.
Okay.
They will be treated at par with the local residents. For 2025-26, there were 6 candidates. Out of that, 2 candidates could made it eligible to be considered. That means coming within 42 seats. But then the other candidate who appears to be coming within 41 position is not before the Honorable Court. And he has not come for counseling also. Petitioner has secured in the 2nd rank.
Second rank in?
NEET examination in the state.
Okay.
In the state.
Amongst all
Therefore-
the candidates from Nagaland, the candidates you secured second rank.
Now, in terms of the Government of India letter, I should be treated at par with the local residents of the state. 1. The merit. It is not only one criteria. The how to select should be strictly based on the merit list secured in the NEET examination.
Okay.
There, the petitioner stood at serial number 2 in the merit list.
Amongst these
Yes.
candidates from Nagaland.
Yes. For 2025-26, the state has got altogether 152 MBBS seats. But we are not concerned with other seats. NICRIMS, RIMS, and then NIMSA, Nagaland Medical College. It's called in short NIMSA. 85 seats. We are not on that. We are strictly confining to central pool of 42 seats. There, I have a right to be considered in view of the instructions and directions and guidelines issued by the Government of India. Secondly, even in the merit, I secured in 2nd position. Therefore, I'm eligible to be considered for admission to any of the medical colleges on the basis of the Government of India instructions and guidelines and on the basis of the NEET ranking.
Okay.
What the state has done, they have reserved 100% for the indigenous inhabitants of Nagaland. So I'm challenging that. This is contrary to the law laid down by the Ethics Code. This is also contrary and in violation of the guidelines issued by the Government of India how to allocate the seats. Seats are given by the Government of India as central pool, 42 seats. That is to be allocated strictly in terms of the instructions issued by the Government of India. But in violation of that, the state has framed issued a notification. By that notification, they are saying that I'm not eligible, so I cannot be considered. But then in the earlier stages, this Honorable Court was pleased to pass an order directing the state government to reserve 1 seat from the central pool. And counseling was held on 4th of August. On 4th, because I have been allowed by this Honorable Court to participate in the counseling. So when I participated in the counseling, they have not allotted even a single seat to me, in spite of the fact that 1 seat should be kept reserved from the central pool. That was also not considered. Why that was not considered? They are banking on the notification of 9/9/2024. So, Lordship, Last
nine.
date for admission is 18th of this month.
No, no, why you were disqualified?
That is why I'll come to that. In short, since let me respond to your query, Lordship's query. Not disqualified, you are not eligible. That is what they are saying. That is, they have framed a policy. That is, in order to avail a seat from the state quota, the candidate should have passed class 10 and 12 from the state of Nagaland. 1. 2. The parents should have been posted in the state of Nagaland for 3 years. Number 3. That is one eligibility criteria.
Do you meet these eligibility criteria? These two?
Yes, they are saying that since you are not eligible in terms of this notification, your case cannot be considered.
No. Which criteria you fail to meet?
That 2 criteria.
You meet none of these 2 criteria.
I don't have that.
Okay.
But this criteria is in violation of the central guidelines. That is why I'm challenging this notification.
Okay.
Coming to reservation. And this 9/9/2021 notification, which is embryoed in this petition. 15% reservation for backward tribes of Nagaland. Out of 100.
No, before that, you are claiming yourself to be a candidate from the state of Nagaland. You are seeking a seat from the state quota. On what basis you are seeking? If you do not meet these 2 criteria.
Seat is allocated by the union government as central pool. In the central pool of 42 seats, in terms of the guideline issued by the government of India, I am eligible and I have a right to claim for that post because I qualify. Put the conditions.
Which conditions?
I should be treated at par as the local residents because I belong to the children of central government employees. But they have not treated me at par with the local residents.
No, central government employee, whether posted in Nagaland.
Yes.
You were posted in Nagaland.
Yes.
But not for 3 years.
Not for 3 years, 24 months only.
Okay.
But central government letter doesn't say this much period should be there, this much, that much period should be there.
Okay.
And Lordship is very
where did you study?
Delhi. I was of class 10 and 12 from Delhi.
Okay.
In order to eliminate this eligibility criteria laid down by the central government, the state has formulated that policy. That is why I have challenged that. Why it is illegal, I'll come to that on that point. But since Lordship is making those queries.
This notification was of which year?
9/9/2021.
21.
Yes.
And you are challenging it when? Now?
Now.
Why? You were not aware about these
That
notifications.
is why, Lordship, it will be better to start from the beginning.
You have
Then
not yet
only
begun.
In a sequence, it will come.
Yes.
In a sequence.
Yes.
Why I'm compelled to challenge this notification only now? That will reveal.
But from 21 to 25, the admissions were done according to this notification
Yes.
only.
There may be no candidate. In 21 also, if I challenge, how can I challenge? I was in class 6, 7.
No.
In 21.
No, before applying for the post against a
I
particular
was not
post.
knowing this notification. And I should have been eligible in terms of the Government of India instruction. But during the motion, this was placed before a noble court. And because of this,
This was not published. Whether the notification was
it
in
was
public
published.
domain.
Is it?
So it is in public domain.
It was not, I was not here that time. But at least it was not displayed in the portal. Only when on 28th, when the petition was moved, I made a categorical submission before the Honorable Court that it is not uploaded even in the portal of the department. In the evening on 28th, they have uploaded it. After hearing my submission,
In the website, it is.
in the website, it was not there prior to 28/7/2025. It was not there in the portal. Otherwise, I should be vigilant. And I was vigilant, in fact, it was not there. After filing the writ petition, when the petition was moved, instructions, all the instructions were there with the government advocate. And in the evening, they have uploaded. I have enclosed in the subsequent petition that when they have uploaded to show that. So, Lordship, I think it will be better if we go in a systematic manner so that.
Yes, Mr. Yangarvati, you are ready. What instruction was?
The respondent will be the state government, Lordship. Yeah, I think
Who
we are
is
ready.
appearing for this?
The Advocate General.
Learned Advocate General is
Read online,
appearing
Lordship.
online, Lordship.
Yes, Miss.
Yes, Lordship, can we come to, there are two writ petitions. Let us first start with 134 of 2025, so that we will not left out or miss anything. And it is a time-bound matter to be decided within the stipulated time. Otherwise, the petition will be infractious also. Page, I'm holding 134 of
Whether
2025.
all parties are ready for hearing.
Lordship,
State.
as per the order passed by this Honorable Court, it has to be heard today.
Lordship, under earlier occasion it was heard.
There are two, three orders, Lordship.
Because the time of hearing since the London City has no instruction, time was given. But this matter was heard by his Lordship, why not?
May he kindly place on record, my lord, whether he has received the instructions and is filing any instructions in this court.
I have not received any instruction as directed by the court, but I will on the materials. Document.
That's all right.
I will rely on the documents that is placed before the court.
What is the status of admission now?
It is open for choice of colleges now at the moment. And last date of admission will be 18th of this month. And before that, this has to be decided after decision by this Honorable Court. We have to apply for the CDC. After obtaining the CDC, again, it has to be furnished to the authorities. Authorities has to make corrections and all these necessary steps. By that time, all the time will be over, Lordship. That's why preference should be given for hearing of this case, Lordship. And in view of that, on the earlier 2-3 occasions, this Honorable Court has passed order that this matter should be disposed of expeditiously as possible. But other day, it could have been disposed of on 6, but then on the basis of the submission made by the Learned Advocate General, that
No.
yes, he wanted to get some instructions, but it was made clear that on that day, if there is no instructions received by that time, then the matter should be heard on the basis of the materials available on record. So it is fixed to the Lordship.
The instruction was to come from Union of India, my lord, not from me.
Documents are
I
very,
said that they had made Union of India a party in this, the petitioner. So I thought since there is a dispute, the right thing would be Union of India should come forward and file their affidavit or give instructions. We are at that stage.
Lordship,
Even without the instruction, Lordship, all the documents are in the place on the record, so I can,
You can argue.
it's in the record. It's
There are 2 writ petitions.
Yes, Lordship, there are 2 writ petitions. And I filed by the state government also.
and by order of this Honorable Court, that IA shall be treated as affidavit in opposition.
Which
IA
The-
held by the state. And
for vacation of the interim order.
yes, that was treated to be an affidavit in opposition. And liberty was also given that if at all any document, additional affidavit was to file, they were also given liberty. That was also filed. We were also given liberty. We have filed affidavit in opposition to that.
Okay.
So far as pleading is concerned, it is completed, Lordship.
Okay, your case depend upon the
Outcome of this case.
outcome of your
Yes,
prayer for quashing of 9/9/2021.
Exactly, Lordship.
notification.
Yes.
If
exactly.
it, if it
Yes.
remains, you don't have a case.
Yes,
If it is quashed, then you may have a case.
yes, Lordship.
Okay,
That is the point. But then,
then let us take up one.
yes, 134, the first case, Lordship. That is the summary of the case. Now, I will just take your Lordship's attention only to the relevant portions where it will be necessary. And I believe most of the queries made by Lordship will be revealed by referring to the documents. Page 16, Annexure A. This is the school where the petitioner has passed her 12th class. In the middle of the name is on the top by bold letters. And if you look at the 5th line, Lordship will find the school, the bold letters, 5th line. It was issued on 13th May 2024. Lordship will find that in the bottom of the page on the left-hand side, page 16, Annexure A. This is the school, how and where the petitioner has passed her 12th class examination. On the extreme right-hand side column, Lordship will find the mark secured by the petitioner, all A1, in all the subjects. In all the 8 subjects, the petitioner secured A1 marks, Lordship.
No, this mark is not relevant.
Yes, yes.
You appeared in a competitive exam,
Lordship is correct.
NEET. How
But-
much marks you got?
I'm trying to show that from where I passed class 12. And then next page
That,
17.
that goes against the notification dated
Yes.
from
how
where you
notification-
have passed.
How notification is illegal, I'll try to satisfy your Lordship.
Okay.
Can we come to next page? Page 17.
Yes.
Annexure P. This is the NEET scoring. In the middle of the page, Lordship will find total marks obtained out of 720, 455. In the middle of the page, Lordship will find that. This is the NEET score. In short, NEET. NEET UG 2025 scorecard. Petitioner obtained 455.
Yes.
And next page is the posting order of the father of the petitioner. Annexure C, page 18. The posting order is on 27th May 2024. It is for a tenure of 24 months. This is the posting order of the petitioner, Lords. He is posted as the commanding officer, first Nagachi Battalion NCC. They have a headquarters here in Kohima. National Cadet Corps. Next page is very
No,
important.
from which time to which time you were posted?
From
always-
this 27 May 2024. So if I'm posted for 24 months, it will be 27 May 2026.
Presently, you are posted here.
Yes. In the NCC headquarters, first battalion.
Okay.
When
Yes.
we come to next page, this is the Government of India instructions. This is one of the vital documents which I'm relying, and this Similar instructions have been followed till 2025-26 Lordship. This is 9 December 1986, issued by the Ministry of Health and Family Welfare, Government of India. Issued by the Joint Secretary. Some paragraphs I may be allowed to read, Lordship, because these are very, very important.
1986.
Yes, and consistently followed till date. Similar instructions. May I read, Lordship, from paragraph 1 to 3 I will read. As you are aware, we have been allocating MBBS PTS seats to your state's union territory for the selection and nomination of eligible candidates. Some instances have, however, come to our notice where some of the allotee agencies have not followed the relevant instructions issued by the Government of India while selecting and nominating candidates against the seats allotted by us. That is very important. Allotted by us. So we are concerned with 42 seats for the state of Nagaland for the academic session 2025-26. Academic year. Number 2, it is once again reiterated that only the children of permanent resident of the state union territory concerned, 2, the employees of state union territory government concerned, 3, the employees of central other state union territory government on deputation to the state or union territory concerned, and 4, this is relevant, the employee of central other state union territory government posted in and having their headquarters within the state union territory concerned will be eligible. Here, Lordship is well aware. The posting of central government employees, normally it is for maximum 3 years. Thereafter, a person will be posted out. Sometimes few months, like that. Number 3, children of central state union territory government employees, aforementioned, should be treated at par with the local resident. This is very important. Should be treated at par with the local resident. The sole criteria for selection will be the academic merit of the candidates, subject to the special orders issued with the concurrence of the Government of India. Now, academic merit was the selection criteria earlier, those days. But after so many years, now the need has been introduced. So the selection criteria is based on merit now, not the academic. But then other instructions, it stands till date. And Lordship will find in the last line of the paragraph 3, the sole criteria for selection will be the academic merit of the candidates, subject to any special orders issued with the concurrence of the Government of India. Subject is given, concurrence is to be taken from the Government of India. This is consistently followed till date, Lordship. And kindly come to next page.
Yes.
I am referring to paragraph 7 at page 20, Lordship.
Yes.
It is requested that the above criteria for the selection and nomination of candidates against the MBBS BDS seats reserved for the central government should strictly followed. So, and then in the bottom, in the last, Lordship will find 2 states union territory without medical colleges. So it was a time when there were no medical colleges in few states. So it was given to those states. So as per this guideline and directive, central government employees, children of central government employees should be treated at par with the local resident of the state. That is 1. And if there is any changes state government wants to make, that should be with the concurrence of the Government of India. So this has been consistently followed. And kindly come to page. 21.
This is letter from Joint Secretary to
Yes.
all. Okay.
9/12.
Okay, but then NEET was not in existence.
Yes, exactly, correct. So that time, it was only academic. Now, after introduction of the NEET, Lordship, kindly come to next page. Page 21, Annexure E. This is also a letter pertaining to 2016. I will just refer to the first paragraph, last 4 lines from the middle of the page, paragraph. Guidelines for allocation of Central Board MBBS BTS seats for the academic year 2016-17 conveyed by the Central Board, conveyed by this ministry, white letter number so and so enclosed. And then kindly come to page 43. The entire comprehensive guidelines have been issued for 2016-17, where the eligibility conditions have been laid down, and then how selection is to be made. All this have been laid down. Similar guidelines and notifications have been issued. As Lordship is in page 43.
Yes.
Kindly come to 1.2 with the bold letters, eligibility conditions. This is the guidelines for selection and nomination of candidates against Central Board MBBS seats for academic year 2016-17. But this is to show that the earlier instructions of 1986 have been still followed till 2016-17 and up to 2025. 1.2 eligibility conditions. Only the children of number 3, the employees of the center, other states, union territory government, on deputation to the state or union territory concerned, and number 4, the employees of central, other states, union territory government posted in and having their headquarters within the state, union territory concerned will be eligible. And then subpara, the children of central government employees aforementioned should be traded at par with the local residents. This is very important. They should be traded at par with the local residents. Whether they have been traded with the local resident or not, that should be examined by your Lordship. Because we are challenging 9/9/2021, that is contrary to the guideline issued by the Government of India, who is the owner of the quota. And then next page, page 44, selection of candidates. 1.4.2. This is up to the introduction of the NEET project.
Yes.
1.4.2. National Eligibility Cum Entrance Test, in short, NET. I will read only 5 lines. In case the beneficiary state, union territory, is not conducting the entrance examination, we are not conducting, the selection of candidate will be made on the basis of the rank obtained in the National Eligibility Cum Entrance Test, NET 2016, being conducted by the Central Board of Secondary Education, New Delhi. So this is the eligibility criteria, how selection is to be made. And 1.5 is the reservation clause, where 22.5% seats have been reserved for belonging to scheduled castes and scheduled tribes. So some percentage of reservation has been made. And thereafter, kindly come to page 49. This is another following letter in the similar line, which was followed in 2024, which is in the same line. But then, since at the time of filing this letter, petition, the instructions for the year 2025-26 was not issued by the Government of India. But incidentally, unfortunately, during the pendency of this case, on the day of filing the writ petition on 28/8/2025, the Government of India has issued the notification, similar notification for current year. But then we could get it only after 2-3 days.
You have a copy of that?
Yes, we have enclosed in the next petition. I will come to that in the affidavit in opposition. Now, here, after page 49, can we come to page 50? This is to show the urgency and how the selection is to be made. Before that, Lordship, in the same page, page 49, Roman 6. In paragraph 2, similar instructions which was in 1986 have been shown. Roman 6, towards the bottom of the page.
Yes.
Any complaints, grievance with regard to the selection of candidates may be redressed in a time-bound manner. So it was last year. And at the time of filing the writ petition, similar instructions was not received. It was not notified yet, but on 28th it was notified subsequently. Can we come to next page, page 50, paragraph 9. It is requested that the state union territory should nominate their candidates on the basis of merit system devised by them, giving in view the above guidelines. The children of All India Service Officers posted in these states or union territories would also be eligible to participate in the said merit system. So, the Government of India letters, instructions and guidelines are very, very clear that the selection will be on the basis of merit, and the children of central government employees should be also made eligible and they should be considered, and they should be treated at par with the local residents of the state. So those instructions are very, very clear, Lordship. There is no doubt about it. Because initially, when Lordship has made a query, an assumption may have been drawn that, look, the quota of central poll of 42 seats is only meant for indigenous inhabitants of Delhi. It is not.
No. I have
In
not,
view of the central government's guideline,
no, I have not assumed anything.
others are also eligible. So now we are referring to the relevant provisions and notifications that, look,
No,
in view of this-
when you say that central government employees are also eligible and should be treated, children of All India Services Officers posted in state are also eligible and should be treated at par with local candidates. How long they should be posted, that clarification is not there in the. So suppose if he is posted there for even a single day, still he is eligible.
At the time of selection, if I'm there, I may be eligible. But that is a very remote case. But then, Lordship may kindly consider one aspect. Deputation is also included. And nobody is posted on deputation for a very long time. It's for a short period only. So, because the employees of the central government, they keep moving here and there.
Yes.
Therefore, in order to facilitate those children of those employees, these provisions are given to few selected states only, because the states where there are sufficient medical colleges, these states are not there. These instructions are confining for 2025 only to 9 states, not to all the states, very selected states. And these seats are also excluding the other seats, like I was mentioning about for Nagaland, names are 85 seats, Rims 10 seats, Nickrims 10 seats. These are not included. These are all reserved for indigenous inhabitants. But we are on the central pool of 42 seats. And how that should be allocated, the government of India has already given clear instructions how to make the selection by the state. It's not that state can frame any role, whatever they would like, and they should make selection. No, they should keep in mind the guidelines, directives issued by the government of India. And my grievance is, look, the instructions given by the government of India is with a clear instruction that it should be strictly followed. When it is clearly mentioned that it should be strictly followed, if somebody violates and not follow, then central government will just say and forget that our instructions have not been followed. So let it be. Can that be? So what is the point of issuing the notification then? What is the point of issuing the instructions and guidelines if it is not to be followed?
Okay.
Can we come to the merit list, Lordship, page 51. This is the merit list of candidates for Nagaland State NIT for the academic session 2025-26.
Yes.
As I was referring to your Lordship, that petitioner secured 455 marks, which Lordship will find at page 17. And Lordship may kindly see here in the name of the candidates and the NIT marks. Extreme left is the name of the candidates, and in the fifth line in the middle of the page, Lordship will find the NIT marks. Petitioner
Yes.
comes in the second position, just above 451 and just below 486.
Why your name is not there?
Yes. Then come to page 98. Why my name is not here? They have made 3 categories, Lordship.
Oh, your candidature was rejected.
No, rejected list is again different. This will make very clear. Page 98, Annexure B, list of category 3 and rejected candidates for Nagaland State. 2 things. Category 3 and rejected list. And in the middle of the page, Lordship will find with both letters, rejected list.
Okay.
Yes.
So
but
first 6 are not in they may be in category 3.
yes. Now, Lordship, here, they have made 3 categories. Number 1 category, general. General, that means indigenous among the Nagas. Lordship is really aware there are some backward tribes. Reservation is being made for those tribes. And general is there like that. So existing reservation policy was there since for the last 48 years. Reservation policy followed by the state.
Okay.
Now, first category, general. That means we can term it as advanced tribe. Category 2, Roman 2 is backward tribes. And category 3 are the ones who falls within, who are the children of single governing employees.
Why category 3 is
They have not clearly mentioned.
Is in the same.
But the immune notification of 9/9/2021 has met these 3 categories.
Okay.
Advanced tribe, backward tribe, children belonging to the central government employees.
Okay.
So we are grouped under category 3. That is in terms of the notification of 9/9/2021. And now, Lordship was mentioning about the rejected list. If I am not qualified and eligible I should be rejected. My candidature should be rejected
Yes.
and my name should happen included among the rejected list. But then, since my name is not among the rejected
Okay.
list,
For a moment, let us see that notification where there are three categories.
kindly come to the next petition, Lord. But Lordship, before that, should I finish this? Because after this, I will refer to only two documents.
Okay.
That is also not relevant.
No.
Thereafter, I'll come to the ambient order. Let us make it very clear, Lordship. Why? I have been,
The candidates mentioned in Annexure B, that is
Yes.
category 3 as well as rejected list.
yes,
None of them have been selected.
none of them have rejected list, though, let us not talk
That
about
is
any
rejected.
selection. But from category 3, none of us have been selected, but
So therefore I am asking, what is category 3?
yes. Category 3
Is
is
it
the children of
That
Central government employees.
you have
that is
submitted.
one.
But
And category 3 has been
is,
met.
is it in any manner similar to reject list?
No.
Why it is clubbed with reject
Yes.
list?
As per the notification of 9/9/2021, they have met 3 categories. So in terms of that, basing on that, this category has been met, and they are saying that as per this notification, you are not eligible. Now, even assuming that we are eligible, how many of them will be selected out of the 42 seats? There will be only 2 candidates, number 1 and number 2. Even number 2, he is not before this honorable court. So we are concerned only with 1 post from 42 central poll seats. And can we come to next page, Lord? Here, the MBBS and allied courses institution and state, Lordship will find serial number 1 and 2. Serial number 1, Government of India, central poll seats for state, 42. And serial number 2, petitioner is claiming from these 42 seats. Number 2, Nagaland Institute of Medical Science and Research, name sir, Nagaland. 82 seats, 85 seats. Lordship here,
Whose document is this?
Lordship,
Who this annexure H?
yes. Issued by the department, Directorate of Technical Education, Lordship.
Nagaland.
Yes. Director's signature is there. Lordship, here, page 99. I just wanted to refer to one thing here.
Yes.
Petitioner do not have any right in the other quotas. Page 99. Petitioner is claiming her rights on the basis of the Government of India notification out of 42 seats. And serial number 2, 85. Why only 85 out of 100? Bimsar has got 100 seats, but why only 85 is shown? Because 15 seats will go to central poll again from this college. And then RIMS 10, NICRIMS 10, like that the other government colleges are shown. We are not concerned with this.
And these 42 seats are maybe from any medical college throughout India.
Correct, Lordship.
Okay.
Because central government is collecting the seats
Okay.
and then allocating to the beneficiary states. Only selected 10 states only, not all.
Okay.
Who do not have sufficient medical colleges facilities. They allocate that with instructions. And then after this, representations have been submitted by the father to the ministry.
No, these
Government of India.
for these 42 seats, the candidates whose parent have served in Nagaland, they are only eligible.
Yes.
That is
Posted.
category 3 persons are
Yes.
only eligible.
Yes.
Then in category 3, there are only 6 candidates.
Yes.
You are saying there are 42 seats available.
And out of that, only 2 persons are qualified to be considered even for 42. And that too, out of the 2, the second one, who is coming in serial number 41 or 42, he is not before his honorable court. He has not participated in the counseling also. So on the strength of the order passed by this honorable court, the present petitioner has participated, allowed to participate in the counseling, but no seat allotment was given. So she is the only one now. So out of the 42, if I succeed, I'll get 1 seat.
And what will happen to other 41 seats?
They are not qualified. They are not qualified. Why? To count 42 seats from the merit list, page 51. Can you see the marks?
No, to whom these 41 seats will go if there is no
Indigenous inhabitants of Nagaland. Entire, whole lot. 41 seats will go to indigenous inhabitants of Nagaland. Out of that also, backward reservation quota is also there. And PWD's reservation is also there, 5%, like that.
Okay.
Am I clear, Rochi?
Okay.
On that. Thereafter, I will not refer to the other documents because these are the representations submitted by the father of the petitioner, 1 representation to the Ministry, Health and Family Welfare, Government of India, 1 representation to the Chief Minister of Nagaland, 1 representation to the Director, Technical Education. The points are mentioned here, but it will not be relevant for us. And thereafter, the notification has been issued by the Director, showing the provisionally selected list and to come for counseling on 30th July, which has been subsequently deferred to 4th August, Lordship. So during the hearing of this petition, the Council for the State already had the instructions to counter at the time of motion. But look, why we have not selected? Because of this 9/9/2021 notification. So most of the documents which I have enclosed in these petitions have already been referred to your lordship in the earlier petition. So I need not trouble your lordship to all this. So kindly come to read petition 138 of 2025.
No.
So since
No,
we have
before
placed that.
Before that, your name is not there in reject list.
Yes.
You are saying that your name is in the list of class 3.
Category 3.
Category 3.
Yes.
And according to you, category 3 are eligible to be appointed.
Exactly. Selected. But
to
no
be
selection was
selected.
made from category 3.
So whether any reason was given to you that
No reason.
for this reason you were not selected?
The only reason given was at the time of moving the petition.
No.
With this notification, as per this notification, you are not qualified. You are not eligible. I mean. Therefore, I am compelled to challenge this 9/9/2021 notification. And it was not in the portal, as I was mentioning earlier. Only in the evening of 2025, on 28 August 2025, they have uploaded in the portal of the department in the evening. That's why we have enclosed that when they have uploaded the document enclosed in Annexure P, page 132. How they have downloaded?
No, before that, I want to understand Annexure B. Why this category 3 was clubbed with reject list? What was the
Rejected list is clearly shown below.
yes?
Studying from
No,
clear one.
why it was clubbed?
Let them say why it is clubbed together. But Lordship may kindly see.
But it
Just
appears
pull up-
that none of these 12 candidates were there in the final merit list.
If I'm rejected, then I should have been rejected in the rejected list. Rejected list starts from serial number 1 and it goes up to 6. So 6 applications have been rejected. So when I'm not rejected, why? Nobody has been taken from category 3. And if nobody is to be taken from category 3, what is the point of making the list also? If I'm not eligible, I should be rejected. No, you are not eligible, you are not qualified. Then it should be rejected in the rejected list. But
Now, where is the document which describes what is category 3?
that's right. Next petition, Lordship. MBO notification. Page 142 is the MBO notification issued by the state. Page 143, Annexure R of WBC 138 of 2025.
In this writ petition, you are only impugning this notification.
Yes, Lordship.
Yes,
Has the Lordship got it?
yes.
It's 9 September 2021 notification. May I read, Lordship? The Governor of Nagaland is pleased to modify government notification dated 30th May 2016 on the guidelines for selection of candidates to the state reserved seats under various central state allotment for undergoing undergraduate courses in engineering and allied, medical and allied, and agri and allied. So I pause for a while, Lordship. This notification pertains on not only to medical, but it pertains to engineering and allied, medical and allied, agri and allied. 3. So in other words, it is a general notification for the entire state. It is an umbrella reservation for few departments, and we are concerned with only one, that is medical and allied. That too, we are concerned with MBBS selection only.
Okay.
Has the Lordship
No, one more thing.
Yes. So
In the earlier application, annexure, page 98, though page 98, writ petition number
124.
134.
Yes.
Though your name was not there in the select list
Yes.
and it was there in the annexure B,
Yes.
clubbed with rejected list.
Yes.
However, in the remarks column, no reasons was mentioned as to why, in spite of getting 455 marks,
Yes.
you are not included in.
Yes.
It is perhaps your name has not been mentioned because of this notification
Yes.
that you do not meet those two eligibility criteria.
Yes.
But that was not mentioned in the remarks column.
That's why we are challenging. And this notification on the ground why we are challenging. The point is, This is contrary to the guidelines issued by the Government of India. That is one. Eligibility criteria, as is mentioned in 1.2, especially paragraph 4, has been violated. I have not been treated at par with the local residents, contrary to the Government of India notification.
Which notification? Which one?
86 notification and subsequent notification
Now,
as well.
after NEET was introduced, is there any notification?
That is 2016 guideline is also there.
Page 41.
Lordship, to make it more clear, for better to rely on 28 July 2025 for this year.
Okay. Where is that?
We have enclosed in affidavit in opposition filed in response to IA 144 of 2025. Affidavit in opposition. In the interrogatory application 144 of 2025 in WPC number 138 of 2025. Page 15. Affidavit, it will be in this form.
Is not there.
Affidavit in opposition.
Please.
It will be there on record.
In I number 144.
Yes.
Page
15. On the right hand side, Nirman Bhavan, New Delhi, dated 28 July 2025. It's an office memorandum. Issued by the Government of India. Has Lordship got it?
Yes.
Yes. So on the top, just below the office memorandum, this is for subject guidelines for allocation of Central Pole MBBS PTS seat for academic year 2025-2026 regarding. So this is a comprehensive governing guidelines for all the Central Pole MBBS seats, Lordship. Starting from 9/12/1986, consistently they are issuing the similar notifications till 28 July 2025 for this year. And kindly come to next page, that is page 16.
Yes.
On the top, Lordship will find this is addressed to cell number 9 on the top of the page. The Secretary, Medical, Health and Family Welfare Department, and then few states are given, 9 states are given. Nagaland is also there.
Yes.
So we are governed by this. And then just below that, guidelines for selection and nomination of candidates against Central Pole MBBS PTS seat for the academic year 2025-26. So we are concerned with the para 1 beneficiary states. Who are the beneficiary states and what are the instructions? Selection of candidates by beneficiary states. So 1.1 beneficiary states, the state union territory, which are deficient in medical education. 1.2 is the eligibility criteria. I'm banking on this, Lordship. More particularly, paragraph 3 and 4. Let me read paragraph 3. Eligibility conditions, only the children of the employees of the central government on deputation to the states concerned. And number 4, the employees of the central, other states, union territory government posted in and having their headquarters within the state or union territory concerned will be eligible. This has made me eligible, Lordship. And then subpara. The children of central or state or union territory government employees aforementioned should be treated at par with the local residents. So this is in clear terms. The instructions have been issued by the Government of India, how selection is to be made by the beneficiary states, and they have ignored this eligibility criteria. State has formed a different policy by ignoring the eligibility criteria, Lordship. That is the reason why we are challenging notification of 9/9/2021 due to violation of these guidelines. And consistently from 9 December 1986, they have been following the similar criteria. And if Lordship is satisfied with that, I'll take your Lordship's attention to the next page, page 17. That is not the only criteria, and there are more conditions. Page 17, 1.4, selection of candidates. How selection is to be made, they have given clearly, Lordship. And 1.4.1, National Eligibility Cum Entrance Test, NEET. Now, after they have violated 1.2 of para 4, they have violated again 1.4.1. May I read, Lordship?
Yes.
The selection of candidate will be made on the basis of rank obtained in the National Eligibility Cum Entrance Test NEET 2025 being conducted by National Testing Agency as per the graduate medical education regulations. That is not required for us. So eligibility criteria is this, given by the Government of India.
Yes.
Serial number 1.1, 1.2, and 1.4 has been violated. And state has made selective compliance. Now, let us come to key area where the state is spending heavily on this, that is 1.5. Just in the same page, little below the center, 1.5 reservation. Has your Lordship got it?
Yes.
May I read? The reservation policy being followed by concerned beneficiary state, union territory will apply on central pole MBBS, BDS seats. Now, this is the key area where the state government is saying that, look, as per 1985 notification, if any changes or if any policy state wants to adopt, the concurrence of central government is to be obtained. That is one of the conditions. Now, state has formulated the policy by the Interim Order on 9/9/2021. There, the concurrence of central government was not taken before issuing 9/9/2021. That is one.
Later on, they have taken concurrence.
They have not.
They have not
They
taken.
have not. From day one, this was my submission till date. They have not said that we have taken the concurrence of the central government. That is one. Second aspect, Lordship, because we have to be very clear on this point. They are talking about the reservation policy being followed. What policy have been followed? Being followed means what? This is the existing reservation policy of the state, that 15% of the seats are being reserved for the backward tribes, for the indigenous inhabitants of Nagaland, who belong to the backward tribes. 15% 50% are reserved for backward tribes, and 5% is reserved for PWDs. These are the reservation policy being followed by the state since many years back. This is what reservation policy means by the central government in their letter of 28 August 2025. But state is saying that, look, central government has given us the power. Look at 1.5 reservation. They have allowed us to frame our own policy. Therefore, there is nothing wrong in framing 99/2021 notification. That is what the state is saying. Now, whether they can apply selective compliance of the Government of India's letter since 1986. Eligibility criteria has been laid down. How the selection is to be made, that is purely on merit. Secondly, the children of the central government employees should be treated at par with local residents. Those things they have ignored totally. Now, another situation. Suppose I have passed class 10 and 12 from Nagaland. This is just a theory, but to understand the logic and reasoning of the notification. I have passed from Nagaland class 10 and 12, qualified. The criteria which has been laid down by 99/2021 notification. My father also served in Nagaland for 5 years, that is above 3 years. So he is also qualified. But I will still not be selected.
Why?
Why? Lordship has put my mouth. Why? Because the reservation policy says 15% for backward tribes, 5% for PWDs. Remaining seats will be allotted to the indigenous inhabitants of Nagaland. Then, I am not an indigenous inhabitant of Nagaland. Therefore, the entire notification guidelines, criteria laid down by the central government.
But you will have to be treated at par with
local
being
residents.
local resident.
Yes. And that was not treated. That is how I am before this honorable court. Simple. Actually, it is a very simple case. We should not have dragged on for so long. And see, selection criteria, eligibility, how to consider, need meaning. Even if I stood in number 1 position, going by the notification, I will not be eligible. So, what's the point of starting so hard? What's the point of securing position 1? Meaningless. Why? It was made meaningless because they have ignored the merit. They have ignored the notification and directives issued by the Government of India. Reservation policy being followed under para 1.5 means about something else, which is being followed by the state. For so many years, for the last 48 years, state is following the reservation policy. And Lordship, can you imagine that 100% reservation is possible under the law of the land at the moment? Lordship is aware about the India Shawnee's case. What is the percentage laid down? Thereafter, subsequent judgments of the Honorable Supreme Court, I will take your Lordship's attention to those areas also, how this notification of 9/2021 is illegal and none is in the eye of law. I will take your Lordship to all these judgments in the later stage, Lordship. But let us first clear the facts. What is the matter about? Power to make reservation policy by the state should not take away the eligibility criteria that has been laid down
No, your main case
by the
is,
Government of India.
your main case is when central government has laid down the guideline, criteria on which
And
the
the eligibility conditions.
on which the wards or children of central government employee would be considered.
Has been
Whether state government can give additional eligibility criteria to that. In this case, what central government has notified, state has added 2 additional eligibility criteria. And your submission is that state cannot do so.
Yes.
Why?
Why they cannot do so? Because the criteria which has been given by the central government and the eligibility criteria and the other instructions given, it was not given to ignore, but it was given to be followed. State government, I'm not saying that state government do not have absolutely no power to make rules. They can make policy, they can make rules. This is an umbrella policy for 3 allied departments. We are not up to that also. We are, because what type of instructions the Government of India has issued in respect of engineering and agri and allied services, we do not know. But at least for the MBBS, medical and allied, there is an instruction and guideline given by the Government of India that is to be followed. While framing the rules by the state for reservation of backward tribes and all that, let them. But please keep in mind about the instructions given by the Government of India, which has been issued to be followed. I believe we should, I think we should go back to 1986 again. Why this was compelled to be issued by the Government of India? The central government had not given the power to the state to destroy and distort the eligibility criteria laid by the center. They can frame rules in consonance with the guidelines and instructions issued by the Government of India. Center has given some limited power to the state to frame policy and rules considering their local demands. For that matter, there are so many seats remaining for the state. They can make rules, but we are talking about the central pool seats of 42, where specific guidelines have been given by the Government of India not to violate, not to make any contrary provisions or law or policy by the state.
Yes.
So, in that background, Lordship, I believe Lordship wants to know whether state is justified in making such a law of reserving 100% reservation policy. What the law also says. Let us look at. I will refer only to 3 judgments. The other day also I have placed those judgments before the Honorable Court. I believe those judgments are also there. So,
yes,
without much ado, I would like to go to the judgments. I do not know whether the copies are available with your Lordship. 3 judgments I have referred to. I will refer only those 3 judgments today also.
where are the judgments? Yes, done. Yes. Tanvi Behel.
Yes.
Pradeep Jain,
Yes,
and Saurabh Chaudhary.
yes, only three, Lordship.
Yes. Yes.
Till 2025, 1984 judgment has been referred and relied upon by Apex Court. Lordship. And very important principle has been laid down. And I believe pursuant to this judgment, the 1986 notification letter has been issued by the Government of India, stating that many states are not following the guidelines issued by the Government of India. Therefore, they were directed to strictly follow the guidelines issued by the Government of India.
Yes.
Now, I will refer to 5 paragraphs only, that too, only the relevant portions, Lordship.
Era?
This is kindly come to para 8. This is a judgment passed by Justice P.N. Bhagwati. Paragraph 8, and in the next page, just above paragraph 9, I will read 6 paragraphs only.
Yes.
Because this talks about the laws made by the state under list 3. The sentence starts with we ought therefore. 6 lines from the bottom, from paragraph 9, just above paragraph 9.
Yes, yes.
We ought therefore strongly urge upon the state governments to exercise this wrong use of expression domicile from the rules regulating admission to their educational institutions and particularly medical colleges, and to desist from introducing and maintaining domiciliary requirements as a condition of eligibility for such admission. Very clear. And paragraph 10.
You know, whether insisting on the criteria that the parent of the candidate should have worked in Nagaland for 3 years amounts to adding domiciliary requirement.
Judgment will take care of all these questions.
Okay.
Hopefully. Paragraph 10.
Yes.
Just above that, in paragraph 9, 3 lines. The sentence starts with the question. The question is whether such reservation or preferences are constitutionally valid when tested on the touchstone of Article 14. Now, turn to paragraph 11. This is to show the end of paragraph 10 for easy reference.
Yes.
Just above paragraph 11.
Yes.
5 lines. The sentence starts with the primary consideration.
Yes, yes.
The primary consideration in selection of candidates for admission to the medical colleges must therefore be merit. The object of any rules which may be made for regulating admissions to the medical colleges must be to secure the best and the most meritorious students.
Okay.
Now, I will take your Lordship's attention to paragraph 20. I have studied the entire judgment, but the paragraphs which are vital so as to decide this case, I am referring only those paragraphs. Paragraph 20.
Yes.
May I read, Lordship? I will read paragraph 20 and 21. The only question which remains to be considered is as to what should be the extent of reservation based on residence requirement and institutional preferences. There can be no doubt that such reservation cannot completely exclude admission of students from other universities and states on the basis of merit judged in open competition. Krishna Ayurji rightly remarked in Justice Saran, his so-and-so, reservation must be kept in check by the demands of confidence. You cannot extend a shelter of reservation where minimum qualifications are absent. Similarly, all the best talent cannot be completely excluded by wholesale reservation. In our case, it is a wholesale reservation. So, A certain percentage which may be available must be kept open for meritorious performance, regardless of university, state, and the like. Complete exclusion of the rest of the country for the sake of a province, wholesale punishment of proven ability to open up, hopefully, some daily talents, total sacrifice of excellence at the altar of equalization. When the Constitution mandates for everyone equality before and equal protection of law may be fatal folly, routine rule of state policy. A fair preference, a reasonable reservation, a just adjustment of the poor needs and real potential of the weak with a partial recognition of the presence of competitive merit. Such is the dynamics of social justice which animates the three egalitarian articles of the Constitution. We agree wholly with these observations made by the learned judge, and we unreservedly condemn wholesale reservation made by some of the state governments on the basis of domicile or residence requirements within the state or on the basis of institutional preference for students who have passed the qualifying examination held by the university or state, excluding all students not satisfying these requirements, regardless of merit. We declare such wholesale reservation to be unconstitutional and void as being in violation of Article 14 of the Constitution. Now, in paragraph 21, Lordship will find how much percentage was also fixed. But then, to what extent can reservation based on residence requirement within the state or on institutional reference for students passing the qualifying examination held by the university or the state be regarded as constitutionally permissible? It is not possible to provide a categorical answer to this question, for, as pointed out by the policy statement of the Government of India, the extent of such reservation would depend on several factors, including opportunities for professional education in that particular area, the extent of competition level of educational development of the area, and other relevant factors. It may be that in a state where the level of education development is woefully low, there are comparatively inadequate opportunities for training in the medical specialty, and there is large-scale social and economic backwardness. There may be justification for reservation of a higher percentage of seats in the medical colleges in the state, and such higher percentage may not militate against the equality mandate viewed in the perspective of social justice. So many variables depending on social and economic facts in the context of educational opportunities would enter into the determination of the question as to what, in the case of any particular state, should be the limit of reservation based on residence requirement within the state or on institutional preferences. But in our opinion, this is the finding. Such reservation should in no event exceed the outer limit of 70% of the total number of open seats after taking into account other kinds of reservation validly met. See, very clear. The Medical Education Review Committee has suggested that the outer limit should not exceed 75%, but we are of the view that it would be fair and just to fix outer limit of 70%. We are laying down this outer limit of reservation in an attempt to reconcile the apparently conflicting claims of equality and excellence. We may make it clear that this outer limit fixed by us will be subject to any reduction or attenuation which may be made by the Indian Medical Council, which is the statutory body of medical practitioners, whose functional applications includes setting standards for medical education and providing for its regulation and coordination. We are of the opinion that this outer limit fixed by us must gradually over the years be progressively reduced, but that is a tax which would have to be performed by the Indian Medical Council. We would direct the Indian Medical Council to consider within a period of 9 months from today whether the outer limit of 70% fixed by us needs to be reduced And if the intermediate council determines a shorter outer limit, it will be binding on the states and the union territories. We would also direct the intermediate council to subject the outer limit so fixed to reconsideration at the end of every 3 years. But in no event should the outer limit exceed 70% fixed by us. The result is that in any event, at least 30% of open seats should be available for admission of students on all India basis, irrespective of the state or university from which they come, and such admission shall be granted purely on merit on the basis of either all India entrance examination or the entrance examination to be held by the state. We have adopted this need only. Of course, we need not add that even where reservation on the basis of residence requirement or institutional preference is made in accordance with the directions given in this judgment, admission from the source or sources indicated by such reservation shall be based only on merit, because the object must be to select the best and the most meritorious students from within such source or sources. See, very, very clear how merit is to be determined, how and to what extent the residential preference should be given and institutional preference should be given. And last paragraph, paragraph 24.
Yes,
Paragraph 24, has the lordship got it?
yes.
Yes. May I read? I will read the first part only. The decision reached by us in these 3 writ petitions will bind the Union of India, the state governments, and administration of union territories, because it lays down the law for the entire country. And moreover, we have reached this decision after giving notice to the Union of India and all the state governments and union territories. So law has been laid down by the Apex Court, as Lordship is well aware, a law laid down by the Apex Court. It shall prevail throughout the territory of India in terms of Article 142. And then after this, after 19 years, this judgment has been again reiterated in Saurabh Dodri's case that is reported in 2003. And before that, Lordship, this judgment is in 1984. After this judgment, the guidelines issued by the Government of India of 9 December 1986 have been issued. I'm not saying from the court, but I feel that since the law has been laid down by the Apex Court, by issuing a direction to the Government of India and to all the states and union territories to strictly follow this. So that 9 December 1986 notification may have been issued, because there it is clearly mentioned that many states are, in spite of the instructions, guidelines issued by the Government of India, many states and union territories are not adhering to the guidelines and the directions. So they are constrained to issue that notification. That is clearly mentioned in that 86 letter, which has been consistently followed till 2025 approach. Can we come to Saurabh Chaudhary's case? I will refer to only a small portion here, starting from paragraph 103 to 108. In this particular case also, Pradeep Jain, which I have referred to, this has been referred and relied upon by Constitution Bench, Lordship. This is a Constitution Bench judgment.
Yes.
Paragraph 103.
Yes.
Pradeep Jain was decided on 22nd June 1984, and this has been decided on 4th November 2003. Paragraphs are very short, so I may be allowed to read this paragraph.
Yes.
Paragraph 103. Similar view was already taken by this court in the Pradeep Jain, this judgment which has been referred. And paragraph 105. The case of Article 15 for reservation, this court has made it clear that the claims of national interest demands that this reservation can never exceed 50% of the available seats in the educational institutions concerned. 106. The view was approved by this court in the case of Indra Shonis versus Union of India. If one looks that all are referred judgments. 107. Of course, as between the reserved category candidates, there should be intrinsic merit observed. This has been emphasized by this court in several cases. 108. As regards the constitutional validity of institutional, regional, or university-wise reservation preferences, in view of this court's emphasis on the need to strive for excellence, which alone is in the national interest, it may not be possible to sustain its constitutional validity. However, the presently available decisional law is in support of institutional preferences to the extent of 50% of the total available seats in the educational institution concerned. And then conclusion is given. I will refer to paragraph 3 and 4. These are relevant for us. So paragraph 3. As regards the scope of reservation of seats in educational institutions affiliated and recognized by the state universities, the constitutional prescription of reservation of 50% of available seats has to be respected and enforced. 4. The institutional preferences should be limited to 50% and rest being left for open competition based purely on merit on all India basis. Up to this judgment, the latest which has been decided on the 29th of January 2025 in the Dr. Danby Pell's case, I will refer to the judgment. I will refer a few paragraphs here. Third judgment, Lordship.
Yes. Yes.
This is a case from Union Territory of Chandigarh. The case pertains to the postgraduate case, admission in the postgraduate. But the principles for MBBS undergraduate has also been laid down in this particular case. And in this case, earlier two judgments which I have cited before, Lordship, has also been taken into consideration by this judgment. And it is purely whether the residence-based reservation is constitutionally valid or not. Two categories have been met here in this case, with slight modification from the earlier two judgments. First judgment says you cannot exceed 70%. Second judgment has reduced it to 50%. Thereafter, Lordship is aware about the Indra Shonis case. Like that. Now, in this judgment, slight variation has been made that to the effect that for postgraduate and specialization, purely merit, no reservation, residence, whatever merit, it is purely merit. But some amount of latitude should be given for undergraduates. So that principle has been laid down in this case, although the main issue in this particular case, Dr. Danby Pell's case, is about the post-graduation after MBBS specialization. So no reservation here, but then some latitude has been given for the residence and state-based, institutional based, that is laid down in this assessment. My Lord, I would like to refer to paragraph 14. Before that, Lord Chimi, kindly come to paragraph 2. The eligibility criteria which the Union Territory of Chandigarh has met is given in paragraph 2. And then in the next page, with the bold letters, Lord Chimi will find UT, P, category P, UT Chandigarh poll. because this will be relevant because it is similar to our case, Lordship. Just below both letters
Yes,
A and B.
duty Chandigarh.
Yes, both. Candidates who fulfill eligibility criteria as below. This category will include candidates with background of Chandigarh. To be eligible for this category, candidate should fulfill any of the following criteria. 1. Studied for a period of 5 years in the Union Territory of Chandigarh at any time prior to the last date of the submission of the application. Number 2. Candidates whose parents have resided in the Union Territory of Chandigarh for a period at least 5 years at any time prior to the last date of submission of the application, either in pursuit of a promotion or holding a job. Number 3. Children of persons who have held whole immovable property in the Union Territory of Chandigarh for a period of 5 years at any time prior to the last date of the submission of 11. The application. The property should be in the name of the parents or the candidate himself or herself. And then after important note just down below, as it is clear, for 64 seats falling under the state quota, all are reserved either for a resident of Chandigarh or for those who have done their MBBS from the same medical college in Chandigarh. So it was about the postgraduate. So kindly come to paragraph 14.
40.
14, 1 4.
14.
14 and 15, and then thereafter 21.
Yes.
The difference in the logic in making reservation on the basis of residence in UG level or MBBS level, the PG level, MT or MS was explained in Jagadish Saran as well as Pradeep Jain. Pradeep Jain is the one of 1984. It was held that at PG level, merit cannot be compromised, although residence-based reservation can be permissible to a certain degree in UG or MBBS course. This is very important. To a certain degree. Because we will be coming to that. Is it 10%? No. Nowhere in none of the judgment 10% has been allowed. While coming down heavily on residents. Based reservation in PG medical courses, it referred to the opinion of the Medical Education Review Committee relied upon in Saurabh Chaudhary's case as follows. And the Saurabh Chaudhary I have already referred to paragraph 15. Why residence-based reservation is impermissible is for a reason that such reservation runs counter to the idea of citizenship and equality under the Constitution. It was said as under in Pradeep Jain. Now, the primary imperative of Article 14 is equal opportunity for all across the nation for education and advancement, and as pointed out by Krishna Ayerji in Jagadish Saran versus Union of India. This has burning relevance to our times when the country is gradually being broken up into fragments by narrow domestic walls. By surrender to narrow parochial loyalists, what is fundamental as an enduring value of our polity is guaranteed to each of equal opportunity to afford the full potential of his personality. Anyone, anywhere, humble or high, acristic or urban, man or woman, whatever be his language or religion, place of birth or residence, is entitled to be afforded equal chance for admission to any secular educational course for cultural group, training facility, specialty, or employment. It would run counter to the basic principles of equality before the law and equal protection of law if a citizen by reason of his residence in the state A, which ordinarily in the commonality of cases would be the result of his birth in a place situated within that state, should have opportunity for education or advancement, which is denied to another citizen because he happens to be resident in the state B. It is axiomatic that talent is not the monopoly of the residents of any particular state. It is more or less evenly distributed and given proper opportunity and to the peak. What is necessary is equality of opportunity, and that cannot be made dependent upon where a citizen resides. And can we come to paragraph 21? Here, the creative change has been reflected. I will read paragraph 21. In creative change, that is of 1984 case, the argument that domiciliary requirement for admission to medical colleges and other colleges situated within the state territory is used not in its legal sense, but in a popular sense, denoting residence or an intention to reside permanently, was also discussed. And this practice of wrongly using the nomenclature domicile was condemned. This is what was said. And then we think it is dangerous to use a legal concept for conveying a sense different from that which is ordinarily associated with it as a result of legal usage over the years. When we use a word which has come to represent a concept or idea of conveying a different concept or idea, it is easy for the mind to slide into an assumption that the verbal identity is combined in all its sequence by identifying identity or meaning. The concept of domicile, if used for a purpose other than its legitimate purpose, may give rise to little radiation, which may, in the long run, tend to break up the unity and integrity of the country. We would therefore strongly urge upon the state governments to exercise this wrong use of expression domicile from the rules regulating admission to their educational institutions and particularly medical colleges, and to desist from introducing and maintaining domiciliary requirements as a condition of eligibility for such admission. Words are very, very clear. Now,
Yes.
again, let me continue. Paragraph 3. So far. Now in India, in one nation, and there is only one citizenship, namely citizenship of India, and every citizen has a right to move freely throughout the territory of India and to reside and settle in any part of India, irrespective of the place where he is born, or the language which he speaks, or the religion which he professes, and he is guaranteed freedom of trade, commerce, and intercourse throughout the territory of India, and equal protection of the law with other citizens in every part of the territory of India. It is difficult to see how a citizen having his permanent home in Tamil Nadu or speaking Tamil Nadu language can be regarded as an outsider in the Uttar Pradesh, or a citizen having his permanent home in Maharashtra or speaking Marathi language be regarded as an outsider in Karnataka. He must be held entitled to the same rights as a citizen having his permanent home in Uttar Pradesh or Karnataka, as the case may be. To regard him as an outsider would be to deny him his constitutional rights and to de-recognize the essential unity and integrity of the country by treating it as if it were a mere conglomeration of independent states. But unfortunately, we find that in the last few years, owing to the emergence of narrow parochial loyalists fastened by interested parties with a view to gaining advantage for themselves, a serious threat has been developed to the unity and integrity of the nation, and every concept of India as a nation is impeded. The threat is obstructive at some places, while at others it is still silent and is masquerading under the guise of apparently innocuous and rather attractive claptrap. The reason is that when the Constitution came into operation, we took the spirit of nationhood for granted and paid little attention to nourish it, unmindful of the fact that it was a hard-earned concept. We allow sons of the soil demands to develop claiming special treatment on the basis of residence in the concerned state because recognizing and conceding such demand had a populist appeal. The result is that sons of the soil claims too not altogether illegitimate if confined within reasonable bounds are breaking us under the unity and integrity of the nation by fostering and strengthening narrow parochial loyalists based on language and residence within a state. Today, this is very important. Unfortunately, a citizen who has his permanent residence in a state entertains the feeling that he must have a preferential claim to be appointed to an office or post in the state or to be admitted to an educational institution within the state vis-a-vis a citizen who has his permanent residence in another state, because the latter is an outsider and must yield place to a citizen who is a permanent resident of the state, irrespective of merit. This, in our opinion, is a dangerous feeling which, if allowed to grow indiscriminately, might one day break up the country into fragments. 23.
Yes.
In the same judgment, it was also explained that merely because a state legislature makes a law on certain subject matters, it will not ipso facto mean that person residing in that state have a provincial domicile. It. The confidence of the legislature is not limited to passing of law which would only apply to persons domiciled within the state. Any law passed by a state legislature can be applied to any person within the state, and therefore the expression domicile has no relevancy whatever in constructing the competency of the state legislature. If the state legislature is legislating on a topic within its competence, that law can be made applicable to anyone in the state of Bombay, whether he is a resident or not, or even if he is a foreigner passing through the state of Bombay. Therefore, it is fallacious to suggest that the doctrine of domicile is introduced in our law by virtue of the fact that the state or the provincial legislature has been given the power to legislate with regard to certain subject matters within its territorial ambit. It therefore seems to us that expression domicile used in any state or provincial law is a misnomer, and it does not carry within the implication which that expression has when used in the context of international law. And then 24. In short, the very concept of provincial or state domicile in India is a misconception. There is only one domicile in India, which we refer to as domicile in the territory of India, as given under Article 5. All Indians have only one domicile, which is the domicile of India. Laws are very, very clear, Lordship, and kindly come to again paragraph 29. What they were the law states, right? Paragraph 29, Lordship.
Yes.
It is now necessary to refer to the detailed reasoning given in Pratit Child as to why residence-based reservation in PG medical courses is violative of Article 14 of the Constitution of India. 2. To maintain a balance and for consideration of local needs, such reservation may be permissible in MBBS course. So, as I was mentioning in the initial stage of this, while referring to this judgment, although this case is pertaining to the postgraduate, the principles for MBBS course is also laid down by the FX court in this judgment.
Yes.
The reasoning given was that it is the state which spends money on creating the infrastructure and bears the expenses for running a medical college. And therefore, some reservation, this is important, Lordship, again, some reservation at the basic level of a medical course, that is the MBBS course, can be permissible for the residents of that state. We are not saying that state do not have the power to reserve the seats. They have the power, but without violating the guidelines issued by the Government of India. Not to flout and make a contrary law by violating the instructions of the Government of India. So some level of reservation can be made for the state. So also they have met in the NIMSA, 85% seats is reserved for the local resident. But 15, leave it open to central board. The classification between residents and others here can be justified as the classification seeks to maintain a balance as it considers local needs, backwardness of the area, the expense borne by the state in creating the infrastructure, etc. Now, here, maintain a balance is also important. Between what? Balance should be maintained, local needs, and also others. What is others? It talks about the central board. There is no absolute power to make reservation 10%. If the state government has any judgment on this point, let them show that state has the power to make law 100%, to make the reservation policy. If there is any law under. Now, can we come to paragraph 31? That's the Lord's Prayer.
Yes.
We are all domiciled in the territory of India. We are all residents of India. Our common boon as citizens and residents of one country gives us the right not only to choose our residence anywhere in India, but also give us the right to carry on trade and business or a profession anywhere in India. It also gives us the right to seek admission in educational institutions across India. The benefit of reservation in educational institutions, including medical colleges, to those who reside in a particular state can be given to a certain degree only in MBBS, for which we have assigned reasons in the preceding paragraphs. See, can be given to a certain degree only in the MBBS course. Postgraduate, 10%, purely unmerited. But some reservation can be given in the MBBS because of the fact that it is the state who spends money for maintaining and then developing the infrastructures and all that. And I'm not on that also, that state do not have power to make law. They have. So they have met the law. This notification of 9/9/2021 is in respect of 3 allied departments: engineering and allied, medical and allied, agri and allied. Agri and allied, engineering and allied, we are not concerned. They can make law, and I do not know whether there is a similar instructions that is given in the MBBS or not. I don't know. So I'm not questioning and not challenging on that also. It is an umbrella policy of the state, but so far as the MBBS is concerned, there is a clear direction, instructions of the Government of India, how it has to be applied. That is why I'm challenging in respect of the MBBS only, not in the entire notification. We are limited only to a specific area. Now, can we come to paragraph 32? I have stopped somewhere in the middle of the page. I have not completed for chapters. Pardon me. I will continue with the rest. I was making a pause. But considering the importance of the specialist doctors in PG medical course, reservation at higher level on the basis of residence or be violative of Article 14 of the Constitution of India. This has been explained with pronounced clearly both in the Justice Saran and Pradeep Jain. If such a reservation is permitted, then it would be an invasion on the fundamental rights of several students who are being treated unequally simply for the reasons that they belong to a different state in the Union. This would be a violative of the equality clause in Article 14 of the Constitution and would amount to a denial of equality before the law. Can we come to paragraph 33? I will end up my submission on the rulings. Thereafter, I will come to the ambient order. Paragraph 33.
Yes.
Having made the above determination that residence-based reservation is impermissible in PG medical courses, the state quota seats, apart from a reasonable number of institutional-based reservations, have to be filled strictly on the basis of merit in All India examination. Thus, out of 64 seats, which were to be filled by the state in its quota, 32 would have to be filled on the basis of institutional preference, and these are valid. But the other 32 seats earmarked as Union Territory Chandigarh pool were wrongly filled on the basis of residence, and we uphold the findings of the High Court on this crucial aspect. Now, what is the finding of the High Court? Can we come to para 4 of the same judgment? What is the, because the finding of the High Court has been upheld by the Ethics Court. That's your Lordship, the paragraph 4.
Yes.
Sub paragraph. To save time, let me just read the sub paragraph. Be that as it may, the High Court held that there has been a violation of Article 14 of the Constitution of India in granting such reservation. Consequently, the clause 2B, 1, 2, and 3, which I have referred to you in the initial stage, Lordship. There are 3 categories criteria laid out, like us. Declared invalid and unconstitutional, and all admissions which were made by the placing on the above provisions were held to be bad. It was directed that the medical college should now fill the seats according to the merit positions of candidates which they have obtained in their NET examination. Now, I think we have almost run out of time.
You continue till 1.
Otherwise, I'm coming towards the end. I will come to the ambient order, how it is not justified, how it is violative of Article 14. Only on that point, I will take about 10-15 minutes only.
Who allots the seats now? Now, what is the stage? Counseling has been done.
Counseling has been done on 4th.
How many seats are available in Nagaland?
152.
Out of these 152,
42 seats is for central pool, and our contest is on this.
out of these 180, for the NEET prescribes that 85%, 15% should be is reserved for central pool of available. No.
The central government has only given directives to the state to follow their guidelines. And the guideline is the children of central government employees should be treated at par.
Okay, at what stage counseling has been done? Whether all seats are filled up?
In terms of the order passed by this Honorable Court on the earlier occasion, 1 seat is reserved. But I will clarify on that point also. They have not reserved the seats in the place where I should have been considered. I have submitted representation. I have been closed in the affidavit in opposition, that thing also. My choice of colleges. Because going by the merit, I should get the second choice. First, number 1, thereafter I should get in which college I should opt for.
Okay, we'll come to
But yes.
after lunch.
Next, my lord.
Yes.
My lord, I beg to mention item 24 of the hearing.
Yes.
My lord, if this matter can come up on 18th, Monday, next Monday. Item 24 on 18th.
Who is for the other side?
I'm not.
Heard Miss Foseco Forte. No. Also heard Miss S. Mere. This is a criminal petition. Item number
Item
24.
24. On request of learned counsel for both the sides, let this matter be listed on 18th of August.
Yes, my lord. My lord, there's an interim.
The interim order shall continue till next day.
Are you obliged?
My lord, Lordship, I am allowed to make a mention for hearing item 22. It is unlikely to reach the such Lordship, if it will kindly be listed on 18th of August, that is next Monday, my lord. I have to consider my learned friend for the respondent, for the petitioner.
22. 21.
Yes, my lord. 22. The first hearing item. I am for respondents 1, 2, and 3.
Okay. On request of learned counsel for both the sides, let this matter be listed
18th.
on 18/8.
Much obliged, my lord. Lordship, I also have a similar prayer for item 21, Lordship. Here, service of notice is still awaited on respondents 2, 3, and 4. Today is the first returnable date, my lord. Right? My lord.
Yes.
We have reliable information that the order under challenge has already been cancelled or revoked by the competent authority, but the written order is yet to reach us, my lord.
You verify we are giving some time.
Yes, my lord.
Heard Mr. Sentianger.
Lordship, and the new office, Lordship, has also already been elected.
No, whether the matter has become infructuous. You find out.
My lord, my lord.
We are,
Yes, my lord, if the written order, if it reaches up, automatically it will become infructuous, my lord. But,
okay, we are giving 1 week time.
If Lordship, it will reach only from Delhi. So if it can be listed up before it's.
Okay. Also heard Mr. No. It appears from record that notices, service report in respect of notices issued to respondent number 2 and 3 have not yet returned.
2, 3 and 4, my lord.
2, 3 and 4 have not yet returned. Stop, await further. List this matter after 4 weeks.
It will get, my lord.
Mr. Lordship, I beg to mention item number 12. Lordship, if this matter can come up on Thursday, my lord, 14, I've taken the consent of the opposite party.
Heard Miss,
Lucino.
yes, heard Miss Lucino, learned counsel for the petitioner.
Lordship, on 14, I will not be available. I thought 14 is Friday. And here's 14 is Thursday. I'm
Lordship,
going to
then,
respond to the 5.
Yes, what is your
Lord, I don't have much to say, but I'm one of the standing counsels for the Principal Accountant General Office.
then
Can you take it on
Lordship,
Friday?
Friday is a holiday.
It's a holiday.
Lordship, then Monday, my lord, 18.
Let it be Tuesday.
Tuesday?
Yes.
Tuesday, okay, Lordship.
Also heard Mr. Miss S. Mere, learned government advocate, as well as Mr. Joshua Sheki, appearing for respondent number 5. On request of learned counsel for the petitioner, this matter is adjourned till Tuesdays,
19th.
till 19th of this month.
Lordship, I also beg to mention item 14, my lord, 14. Lordship, if this can come up on Thursday, 14, my lord, I have taken the consent of the opposite party.
Heard Miss Lucino. Also heard you are appearing. Moim Chin, learned senior government advocate who does not opposes the prayer for adjournment by the learned counsel for the petitioner. The matter is accordingly listed.
14, my lord, Thursday.
Okay, on 14th.
Pleasure.
Lordship, in item 21, there is an interim.
Item number 21, interim order shall continue till next day.
I'm deeply obliged.
Lordship, I beg to mention item number 30. This matter has become infructuous, Your Lordship. This petition was filed for staying the departmental proceeding, but there was no interim. So during the pendency of the case, the department has already passed an order.
What is your name?
Zakato Chishi.
Heard Mr. Zakato Chisi, learned counsel for the petitioner, who submits that this writ petition has become infructuous. Also heard Mr. Yangarvati, learned
All the respondents.
counsel for
All the respondents.
all the respondents. Learned counsel for the petitioner submits that this writ petition has become infructuous. Stop. Considering the submissions made by learned counsel for the petitioner, this writ petition is disposed of on becoming infructuous.
Pleasure.
Wait, Mr. Lordship, I beg to mention item 11, Lordship. Lordship, if this can pass off for the day, Lordship, there is an urgency in this matter, Lordship.
Item 11, somebody mentioned in the minutes.
Lordship, yes. The respondent, the largest counsel, he mentioned, Lordship, however, this, the matter is still half heard, so it might not reach my item, so.
Okay. considering the paucity of time today, this matter is passed over for the day. Yes.
Just at the end of the first half, Lordship was putting a query that what is the present position,
Yes.
present status. Counseling was held on 4th as allowed by this honorable court. As directed by
4th
this-
of August.
4th of August. I have also participated in the counseling.
Counseling is before which authority?
Before a Directorate of Technical Education, they had a nodal department.
State,
and the concerned
state.
department, yes,
Okay.
who is conducting the counseling.
Thereafter,
Thereafter, they have prepared the provisional list. No final list has been published yet. It is not uploaded in the portal of the department till this morning. So it is not final. It remains a provisional list. One. Even assuming a final list has also been published, suppose. Lordship is aware in Dr. Danby's case, which is decided by the Supreme Court on 29th of January 2025. The High Court, immediately after the admissions were made in violation of the central guidelines, writ petitions were filed. Out of the 64 seats in the Union Territory of Chandigarh, 32 seats, which was pertaining to Central Port, where the admission was taken, has been quashed by the High Court and directed the state to fill up the post in accordance with the criteria laid down by the Government of India. That decision was upheld by the Apex Court on 29th of January 2025. So,
now whether the candidates have taken admission?
not yet. Choice of selection of two colleges is
No,
till today.
what you are submitting, say, assuming that this, you are, a favorable order is passed, assuming, then without the affected candidate, whether,
With party,
yes,
I will give a spontaneous reply on that, Lordship. If any person is illegally acquired a right, what will be the value of that right, such a right? Whether it can be treated as a legal right or not.
the list, in the provisional list which has been issued, whether one seat has been kept vacant.
Who are in the central pool out of the 42 lists, it is not yet declared at the time of filing this writ petition. And it was supposed to be disposed of the other day. But then, to obtain instructions, time has been sought for. But on 4th of August, when this petition was moved, I made a categorical submission before the Honorable Court to the effect that, look, I'm saying that this is contrary to the guidelines and state do not have the power to make a contrary guideline or policy, contrary to the Government of India guidelines. On that point, to respond under paragraph 1.5, the state has been allowed to frame our policy. But the reservation policy being followed by the state means it talks about other reservation policy. Therefore, since the owner of the seats, the owner of the letter is the Government of India, so let the CGSC obtain instruction. What do you mean by this reservation policy? That was ignored. On 4th, if the matter was listed, on 5th, what happened? The Senior Government Advocate Nagaland made a submission before the Honorable Court that I learned that the Learned Advocate General is coming For what purpose he is coming, I do not know. But this case may be deferred to tomorrow. That's how the matter was not heard on 5th, and it was deferred to 6th. Next day, the learned Advocate General was in the state. He appeared through online and then made the same submission which I have made on 4th of August 2025, whereby I have said that, look, let the CGSC may be directed to obtain instruction if they are saying so. But on the face of it, the central government doesn't mean that this reservation policy is to deviate and to pass a frame of policy contrary to the guidelines issued by the government of India. Same submission and the same point. The submission which I have made has been ignored, and that day that is court. Everything is on record. If I have not made such a submission, Lordship can also see. But on 6, after conclusion of my submission, the learned Advocate General made that submission, concession that since the Indian government is also made the party, from day one they were made party. That is why I have made a submission before this Honorable Court to direct the CGSC to obtain instruction. That was ignored. But the same submission which the learned Advocate General has made, on that ground the matter was deferred to here today. In the process, there may be so many developments. That is how, who has created this problem? If I have created a problem, I should have a way out. I should have a solution with me because it is created by me. But if somebody has created the problem, it is your outlook to solve the problem. Now, I have submitted an application. After this Honorable Court pass an order directing the state to reserve 1 seat for Central Port from the Central Port. This Honorable Court has passed an order. I submitted a representation. Look, the Honorable Court has passed an order to this effect. So these are my choice of colleges during the considering. This may be considered. And if you fail to consider this, then whatever problem is created, if you afford not to listen to the direction of this Honorable Court, it's up to you. But this is the order passed by the Honorable Court, and these are my choice of colleges. That was the application which I have submitted. Therefore, it cannot be said that since they have already done rightly or wrongly, already done, already gone, that should not be. If we are to maintain the rule of law, if the justice is to be upheld, if the law of the land is to be upheld, then the law is sent to all. A junior most counsel may submit, senior most counsel will submit. Law is sent to all, whether he is rich or poor,
Okay.
mighty, even for a victim, law is same. Therefore, similarly, the submissions made by the councils from the bar, value is same. Whether it is the learned Advocate General, whether it is any council, law is same. So those should be treated same, equally. Not that when I make a submission, that should be ignored. Not that when a senior counsel is making submission, that should be honored.
Now you continue where you left.
Yes. Lordship, before that, just one point. Lordship was also making a query on the seats collecting from the all over the country. 15 seats are reserved for Central Kota.
Out of 100.
Yes. That is the reason why even in NIMSA, the Medical College Nagaland, 85 seats belong to the state. They can frame any role, they can fill up the seat in whatever manner they want to. So also along with that, these nicknames, 10 seats, rims, 10 seats, they are all one. 15 seats is taken away by center. And that will be filled up by applying this ratio reservation, all these criteria, center will fill up this 15 posts. Over and above all these seats, 42 seats is being allotted to the state by the center, not to all the states, very selected states, as in 8. The state of Nagaland is lucky to have these 42 seats. And there, provisions are there. These 42 seats are allotted to the states, few states only. And along with that, guidelines are issued by the Government of India. Minister of Health and Family Welfare.
These 42,
Yes,
who are eligible? You are one of the,
yes, eligible.
and who else? What other categories?
So the merit is indigenous inhabitants of the state of Nagaland, and the quota which is being given in the Government of India guidelines. Kindly see 1986 notification.
Okay.
Page, because it will be better to clear the entire concept. Page 28 of the writ petition document.
First one.
138 of 2025. Paragraph 3.
Yes, page.
From paragraph 2, it is once again reiterated that only the children of number 1, permanent resident of the state, union territory concerned. 2, the employees of state, union territory, government concerned. 3, employees of the central and other state or union territory government. We are here on deputation to the state or union territory concerned, and the employees of central, other states or union territory government posted in and having their headquarters within the state or union territory concerned will be eligible. This has made me eligible, and similar directions have been issued from time to time every year. And
Okay.
this is how I have been made eligible. And then the 3, the children of central state union
Now
territory
suppose
government employees.
in this case you are found ineligible because of you're not conforming to 2 criteria. So that seat will be filled up by a permanent resident of out of the one of these 4 categories. Okay.
Lordship, that is why I was making a submission in the initial part of my submission. One aspect very clear. Even if I fulfill the criteria of studying, passing class 10 and 12 from the state. 1. 2. If my father is posted in the state for 5 years, more than 3 years, even then, I will not be eligible. Why? Because 100% seats have already been reserved. Thereby, it runs contrary to this notification, this letter, and these instructions. And these instructions have been consistently followed till date. And Lordship has seen in the letter of 28 July 2025 pertaining to this year's selection and allotment of seats. The same condition is shown. And so far as the central seats are concerned, 15 seats which has been taken out from LIMSAT, state do not have the power there. Center will allocate and fill up these seats. State 85, you make any kind of law. Reservation backward, this much seat we should get, PWDs will get this much. That is the policy of the state, There, the state has the power to make rules and policy. We are not against that. We are not done that. We are not done 110, 12 seats, only 42. It confines to only 42. And there I'm eligible as per the Government of India guidelines. But by framing the arbitrary rules, policy, I have been deprived of that right, which has been granted by the Government of India. So I would like to come to the Indian order. Read petition, page 142. One today.
How much time will you?
I will not take much time. This will be the last. And I will submit and substantiate on this.
Yes.
So and then in my affidavit, the subsequent developments I have placed on record, only that much. It's 9 September 2021. Has Lordship read it?
Yes.
May I read, Lordship?
Yes.
Since this is the embryo order, I may be allowed to read the entire notification.
Yes.
The Governor of Nagaland is pleased to modify government notification dated 30th May 2016 on the guidelines for selection of candidates to the state reserve seats under various central seat allotment for undergoing undergraduate courses in engineering and allied, medical and allied, and agri and allied. So as I was mentioning, Lordship, this is an umbrella reservation policy for few departments. We are concerned with the middle one, that is the medical and allied. That too, others we are not there, but in the for the MBBS seats, allotment seats. So we are not questioning that. Eligibility, paragraph 1. There are 3 categories. Category 1, members of recognized indigenous scheduled tribes of Nagaland as notified by the Government of Nagaland from time to time. We are not there. We are not questioning that. Category 2, members of recognized backward tribes of Nagaland as notified by the government from time to time. We are also not there. The challenge made is in category Roman 3. A. Candidates belonging to the non-local indigenous inhabitant of Nagaland as per Premier Department Notification 28 April 1977. We are not there also. B. We are here. B and there are 2B, but it should be B and C, I think. I think it is a typing mistake. A. Candidates, B. Children of non-local state government employees and children of all India service officers born on Nagaland cadre to be eligible under category 3. B. This will be C, I think. The candidates should have appeared class 10, 12 or equivalent from any of the schools within Nagaland, and his parents should have been residing and posted in Nagaland for at least 3 years or more. Both the criteria should be fulfilled. We are challenging this. These are the 2 conditions which we are challenging. This is contrary to the guidelines issued by the Government of India. 2. Central government guidelines have never left any provision for the state to frame a contrary role in contravention of the central guidelines. If any role is framed, it should be in accordance with the guidelines. Number 3.
Yes.
If any policy is framed by the state, the concurrence of the Government of India should be obtained. Here in the letter, in the next page, Lordship will find they have sent to so many departments, but none of the copy has been endorsed to Government of India also. This very fact shows from the records that they have not taken the concurrence of the Government of India to frame this rule. Now can we come to paragraph 2 of the interim order? Lordship is on page 142.
Yes.
Reservation. In the poll letters it is given. The state reserved seats for undergraduate, technical and professional courses are reserved for the candidates belonging to the indigenous scheduled tribes of Nagaland as follows. A. Backward tribe reservation, 15%. In short, let me stop there because it is clear. 15% is reserved for backward tribe of Nagaland. B. Persons with disability reservation, 5%. In short, PWDs, that is 5%. And C, we are agreed by this again. The remaining seats, that means up to 20%, how much will be left? 80% seats will be left. The remaining seats, that means 80% seats, shall be filled up amongst the candidates belonging to the indigenous scheduled tribes of Nagaland, securing minimum qualifying marks of so and so, so and so. That will not be required. But the substance is, remaining seats shall be filled up by the candidates belonging to the indigenous scheduled tribe of Nagaland. So I will not be made eligible by this also. So 20% plus remaining seat 80% comes to 100%. That is the reason why I was making a summation, Lordship. Even if I passed class 10 and 12 from Nagaland, and even if my father is posted in Nagaland for more than 3 years also, by fulfilling that also, that two criteria, which the one, even then also, I will not be eligible.
Okay.
I will not be eligible. That means, what is the object of making the law? To reserve 100% for indigenous inhabitants of Nagaland, plus this PWD is 5%, that is also indigenous inhabitants. Lordship has sent a law later by the Apex Court.
Yes, okay.
The underlying policy of the government of India of making the reservation is equality and parity also. There is, in every law, there is a philosophy behind equality and parity. The governing guidelines issued by the government of India is with that philosophy. Equality should also be maintained, parity should also be there, considering the needs of the local needs of that particular area. So, Government of India has never directed to frame additional policy in contravention of the guidelines issued by the Government of India. Therefore, this policy of reserving 100% and the category 3 clause B and C and the paragraph 2 framing the reservation policy 100% for the indigenous inhabitants of Nagaland is arbitrary, discriminatory, illegal, and violative of Article 14 of the Constitution of India. The only object is to eliminate others. Possible. That can be the possible objective. Otherwise, it is against the law of the land. Contrary to the law laid down by the Apex Court.
Okay.
So, one point which is vital, whether 100% reservation is possible or not. One, whether concurrence of the Government of India has been obtained or not, as has been mentioned in the Government of India's letter. Whether I have been treated as at par with the local residents of the state. They have not. Therefore, they have adopted a selective compliance of the Government of India. 1.5 they have adopted, thinking that it will be of some help to them, so as to take a refuge in that central government has allowed us to apply our reservation policy. That reservation policy is being followed by the state since long. Reservation of backward tribes. All these reservation policies are there. Central government means about that policy. And otherwise, Lordship, what is the meaning of inserting other conditions? Eligibility criteria and need merit has been ignored totally. And I have not been treated at bar with the local residents, resident of the state, sorry.
Okay.
The office memorandum of 28/7/2025, which pertains to 25-26 academic session, has to be meticulously followed by the state. And if it is not followed, it is in violation of the guidelines of Government of India. And the reservation policy of the state have not left any scope for consideration of all India service, even if found eligible, as I was mentioning, Lordship, as per the notification of 9/9/2021, as per your own notification, even if I am found eligible, fulfilling two criteria that I have passed 10 and 12 from here, my father has been posted here for so many years, even then also I will not be qualified. That means
Okay, you are starting repeating. Now, if it is over, then we hear other. You may reply to.
Let me continue with the Indian order. Paragraph 3, selection.
Yes.
A, page 143. That's the Lordship got it?
Yes.
Yes. A, selection of candidates to various state reserved undergraduate, technical and professional courses shall be through entrance examination conducted by the state, central government, other agency, as notified by the state government. B, only those candidates who secured the required minimum qualifying marks in the entrance examination shall be considered for selection. C, selection shall be made based in order of merit of candidate in the entrance examination result, preference option exercised by the candidates, and availability of seats. Separate merit list shall be maintained for all categories. And then D will not be relevant. E, this is very, very important. If seats are available after selection, after selecting all eligible and qualified candidates belonging to recognized indigenous tribe of Nagaland, then selection of candidates under category 3 will be considered. Preference will be given to the following order: candidates belonging to non-local indigenous inhabitants of Nagaland, children of local state government employees, and children of all India service officers born on Nagaland cadre. Now, see, as per this, especially E, is it not to eliminate others? If seats are available after selecting all eligible and qualified candidates belonging to the recognized indigenous civil tribes of land. This means after the allocation of seats have been done, and if anybody comes and say that no, although I have been allotted, state government was so gracious to allot me a seat, but I don't want to study, so I'm surrendering this seat, MBBS seat. Therefore, such a seat should be given to this category 3. That means the children of central government employees. Then what the Government of India notification says about the children of all India central service employees.
Now, whether category 3 candidates will get admission only if they comes within the stipulation E.
E,
Only
if seats are available after selecting all eligible and qualified candidates belonging to the recognized indigenous civil tribe of Nagaland, then selection of candidates under category 3 will be considered. Government of India guideline have not said to make category 3 as a different class. The only criteria laid down by the Government of India is the children of the national government employees should be treated at par with the local residents of the state. 1, 2, need meeting. Only these 2 conditions are given. And I fulfill that.
yes.
Other day, the learned advocate general was making a submission. State of Nagaland is totally different, very difficult
No.
to maintain. All these submissions have been made. Now, I have a point here, Lord. The ratio. Because considering his submission as if we are very much deprived and do not have the privileges, considering and comparing with other states, how medical seats are allotted. 1:30, 1:30 qualified and eligible candidates. State 1:5, only 5 candidates for 1 seat. State very fortunate because considering the number of population, the number of seats are 152, a huge number. Whereas, think of the population of Bihar, UP, for that matter, many other states in the country. 1:30.
Okay.
So we are very, very fortunate than those states. Therefore, such a submission is absolutely irrelevant, Lordship, to make any comparison with that. And so let me just conclude. Only 3 points I'm referring. 1,
If you don't wind up, the hearing will spill for another day. That may not be in your benefit.
yes. So by taking 2 minutes, I will win up. The guidelines issued by the Government of India has been violated. I should have been treated at par with the local residents of the state. That has been ignored totally. Many times I'm submitting on this point. 2, merit has been ignored. Merit criteria has been ignored. Only selective application has been made by the state. Number 3, concurrence of the Union Parliament, Central Government has not been taken.
Okay.
Number 4, giving in view of the law determined by the Ethics Court, 100% reservation by notification dated 9/9/2021 is contrary to the law laid down by Ethics Court. It is contrary to the law of the land. Therefore, the provisions under which I am challenging with respect to the MBBS only, it is an umbrella policy for other departments. We are not questioning that because there is no specific directions by the Government of India in those. It will have to be decided in terms of that such direction. But so far as the MBBS selection is concerned, there is a clear guideline and direction by the Government of India. So it has to be strictly done in accordance with that. And after the order has been passed by this Honorable Court, I have submitted my application. Lordship may kindly see my affidavit in the possession. Initially, I have referred to that. Page 23. At page 22, they have issued me the call letter to attend in the counseling. And I have submitted my representation showing my options for the counseling. And in paragraph 4, I have categorically mentioned like this. You are requested to reserve one seat for MBBS from the above choices as per my late meeting, as per the governing directions of eligibility and seat selection for central poll seats as laid out by Government of India, Ministry of Health and Family Welfare. Any subsequent financial litigation or any other liability arising due to non-compliance or wrong considering my choices by the Directorate of Technical Education shall be borne fully by the Directorate of Technical Education, Nagaland. So with this, I have submitted before the council. I have placed the order passed by this Honorable Court, but the merit has not been considered. Reserved one seat. Government of India guidelines have been violated, but this is just a provisional list.
Do you have the provisional?
By ignoring my representation, they have proceeded.
Do you have the provisional list?
Provisional list, yes, I have.
After the counseling,
No, after the counseling, I do not have.
you just submitted that a provisional admission list has been
The do not
notified.
notify that.
Okay. Yes,
Lordship, this Honorable Court has passed an order that reservation of seat will be subject to the final outcome of the case, outcome of this case. So after the case is finally decided by this Honorable Court, then they have to make according to the direction passed by this Honorable Court.
where?
Final list has to be. That
Where
order.
is that on?
IA.
Yes, Marty.
144.
According to the Honorable High Court order, only one seat is reserved. It is not specified to which place.
Page 28.
Of which order?
Yeah, yeah.
Is an IA 144.
Para 20.
It's in para 20 of that order, my lord. Para 20.
Page 20. There is no para 20.
My lord is not.
We are talking about para 20.
20, where they say thereby there is.
Can we come to page 28 of the IA 144 of 2025? They are talking about earlier order. I am talking about the subsequent order.
Yes.
Which has crystallized.
Which para?
Paragraph 9. Page 28. In the bottom of the page, the entire counseling and selection process shall be subject to the outcome of this state petition as far as one seat in the central poll is concerned. It is clarified herein that the one seat which was directed to be explored in the order dated 28/7/2025 will be from the central poll.
No.
Very clear. But
No specific.
even here also, Honorable High Court has not said any specific where reservation is to be made. It will not. Certainly not. But what is the guideline and criteria? Merit. And merit has been ignored. Lordship, can you see whether the merit has been honored or merit has been ignored? Can you see from the action of the state response? And if they have resorted to any illegality by ignoring the order passed by this Honorable Court, it is this Honorable Court who can rectify and correct and issue a direction for any consequential action
Okay,
done by the state lordship.
okay, yes.
I believe I should conclude with that. There are so many things I wish to convey, but then considering the time factor,
You may continue if you wish.
the lordship, I should be equally conscious about the timing also, because
Okay, yes, state government. Yes,
time is
Mr.
very
A.
short for admission.
In the first place, I would like to have a clarification from the learned counsel representing the center, whether he has any instructions. If he doesn't have, I'll proceed. If he has, he may convey.
No, he,
I have not received any instruction.
Then I will go ahead. I will go ahead.
I'll make my submission as per the reports.
his main submission, what I have understood, is that in notification dated 9/9/2021, you have incorporated some additional requirement which were not contemplated by the central government guidelines. And you have made it so as to reserve 100% reservation for indigenous. So therefore it is bad in law. That is the crux, what I have understood. What is your response to that? Yes,
I
Mr.
can- I may proceed, madam?
Yes, yes.
Please. I will just clarify some inadvertent errors which may have been pointed out by my learned friend.
Yes, please.
He says that in this NEET exam, he has obtained the second rank.
Amongst the,
Persons in Nagaland.
yes,
Her all India rank is 1,11,803. This is the actual rank.
One
One
lakh 13,000, sir. 1,13,000.
1,13,803.
803. Yes.
This is the rank.
Yes.
Then I will briefly touch upon some of these facts. First, starting with the 15% reservation. That is all India. Out of 100 seats, 85 for indigenous and 15% for all India. Those seats is completely controlled by central government. We have handed over that full freedom to that. That is also an area where she could have applied and registered. This is my first submission. State government has no say in this.
But those 15% seats are not specific to Nagaland.
No,
Anybody-
in fact, we surrender it to the central government. Central government can do what they want. They want that 15% from us. They will give it to whomever they want. You can apply even under this 15% if you are a central government employee.
But for that, whether this requirement of parent working in Nagaland would.
Nothing. In fact, this is something completely dealt with by the central government alone. We have no
Anybody
say.
can apply.
We have no say.
Okay.
That is one. Secondly, my lord, what are the other avenues open to one such candidate? There is another quota that is called Central Pool Quota to Ministry of Defense.
My lord, I may be allowed to submit the documents.
Place it. She's placing the document. This is exclusively for Ministry of Defense. And in this central pool, they have 42 seats.
In this central pool, they have 40.
They have 42 seats. We have got nothing to do with that. Naga people don't have any right over even one seat.
For the Ministry
This
of.
is exclusively for the defense. This is the second option.
This is irrespective of state consideration,
Yes.
whatsoever state may be.
Yeah, and here I have given the details. How many seats in which place, everything has been mentioned. Nagaland is not there, part of it. It's purely their discretion. We have nothing to do with it. This is for defense. They can register under this also.
No, but the submission of learned senior counsel for the petitioner, what I have understood, is harping on these 42 seats because these 42 seats are to be filled up according to the central government.
I am coming to his contentions. I'm just placing some additional facts for the consideration of this court.
Your submission is that for these 42 seats, anyone from defense, any ward of defense personnel may apply, irrespective of the requirement of being posted in Nagaland or not.
Nagaland has nothing to do with it. We have nothing to do with it. Kindly see. It's issued by Government of India, Health, statement indicating allocation of MBBS MD seats from Central Pool quota to Ministry of Defense for the academic year.
Lordship, may kindly permit.
My third submission is, my lord.
No, let me understand this submission first.
Very.
Then why it is shown against the state?
In fact, the seats are located in different parts of India where you have these medical colleges.
No, to whom these 42?
All 42 is under the complete 100% control of the Government of India, and they give this only to the defense personnel children.
Defense personnel posted where?
Nothing is mentioned here. Ministry of Defense for the academic session.
What is the meaning of showing it against Nagaland?
Lordship,
No, it is not mentioned against Nagaland. This 42% is separate from the central pool of Nagaland.
Additional seats.
We have central pool for Nagaland, which my learned friend was talking about, to which I will shortly refer to. This is independent of that. The state has got no business with this. This is just to show that under the defense pool, they have 42 seats. We have got nothing to do with it.
Okay.
It's complete, but in our central pool, we have a separate 42 seats. That has got nothing to do with it. They are so both distinct and independent.
The defense personnel also, they have their own reserve seats, Lordship, from the central pool. So for 42 seats are reserved for the defense personnel, for the children of the defense personnel, is what my learned AG is submitting.
She could have applied in this quota also.
So this list which you have given, it does not have two columns. These are continuous rows.
Lordship, this is apart from the 42 central pool seats allocated to the state of Nagaland. Apart from the 42 seats allocated to the state of Nagaland, the Ministry of Defense also, they have their own seats. 42 seats are reserved for the children of the defense personnel. So what my learned AG is saying is that the petitioner would also have a line here.
Separate. I'm coming to our 42%, 42 seats.
No, is there any document notification or order where the seat distribution from central pool quota is shown.
Second,
See the very document which has been submitted to your lordships. And
Second-
seat distribution, there's one more paper. Kindly hand it over.
yes, I've already handed it. It
In
says-
that, if your lordship were to see, Ministry of Defence is the third one. Seat distribution of central pool quota, Ministry of Defence. My lord has got that, my lord? A single sheet of paper.
Which one?
The single sheet. This one.
Yes.
So
Yes.
in that third one is Ministry of Defence.
Yes.
My lord has got that, my lord?
Yes.
Now, just for the sake of clarification, this is shown as Nagaland 42%, separate.
40%.
Below Nagaland,
Okay,
42.
okay. For
So
Ministry
they are
of,
different.
so
The
Ministry
matter
of
is clear.
Defence also 42
Yes.
seats there, and for Nagaland separately 42.
Separate 42%.
Okay. Yes,
Then,
please.
my lord, in India, we have about, we have in total 605 recognized medical colleges.
How many?
605. There may be many other colleges. The list I've seen is shown as the recognized ones.
Yes.
The candidate, my lord, is from Haryana. My lord has got that list also.
Yes.
In Haryana, the number of colleges are 13.
Yes.
So she has further opportunity in her own state.
Yes.
Therefore, before I go into the Nagaland quota, I only want to bring to your lordship's notice that she has various avenues open to her to avail of a medical seat.
Okay.
Whereas as far as the Naga people are concerned, indigenous people, they have only what has been given here. That's 85 and the central 2. We don't have anything else. For a moment, if I may so, the medical colleges came into existence after we became a republic. That is in 1950. Your lordship has any query, my lord?
No. Please
Okay.
continue.
Please. So if in 1950, let us presume there was one medical college in some state. After 75 years, they would have churned out 7,500 medical students at an average. I'm giving the lowest.
Okay.
But there are many states which have like 55, Maharashtra, then Andhra Pradesh 38, and so on. UP also is quite a large number. We have all that. I'm saying just take it as one college. So where is Nagaland today? We are today at the place where they were in 1950. What was their position 75 years ago? That is our position today. Unfortunate position, we have got a medical college so late. 2023.
Yes.
2023, we had this. Did we have central quota before 2023? That's another question. So we didn't have medical college. The answer is yes. There was a central pool for the indigenous Nagas prior to 23, I think I have record from 2007, that's what the secretary told me, where we had a central pool exclusively for us,
Exclusive of?
exclusively for the Naga people, indigenous.
Okay.
In that there is no share for anybody. But only difference is we did not have a medical college then. Now we have a medical college. That's the only difference. So even from the time we were given central quota, the central quota consisted of whatever seats are available, which keeps fluctuating, maybe 39, 40, sometimes higher than that. That was given to the Naga inhabitants because we did not have avenue for any other seat anywhere.
Okay.
That very central pool is now continuing. This I mentioned only to show what are the different avenues. Now, my lord, I'll clarify some of the questions which you have taken. They have referred to 9th December 1986.
Yes.
I think I am having it at page 19, I think.
Petition 134.
Petition 134. Am I right, Supre?
Yes.
My learned. Yes.
Page 19, read petition 134.
Yeah. I'm good.
Yes.
Now again, I will read again 2. There are 2.
Yes.
It is once again reiterated that only the children of 1 permanent residents of the state public duty concerned, the employees of the state public duty government concerned, the employees of the central other state public duty government on deputation to the state duty concerned, all these 3 don't apply. 4, the employees of the central other state duty governments posted in and having their headquarters within the state duty concerned will be eligible.
Yes.
So here they speak of having been posted.
Yes.
No clarification has been given as to what is the term of their posting, as your lordship had pointed out. It only uses the word posting.
So it means that if a central government employee is posted in Nagaland or posted on deputation in Nagaland,
Please.
and he becomes eligible as one of the category.
That's what this says. This is what it says. Now I'll clarify next paragraph.
Yes.
Do they have the headquarters within the state?
This is a unit of a headquarters.
And it says posted in and having their headquarters within the state. This is NCC. If I'm right, this
Shillong.
headquarters is at Shillong. Not in Nagaland. But Nagaland has a unit area headquarters. But the word used is their headquarters. They will be eligible. Third, my lord. The children of central state duty government employees above mentioned should be treated at par with the local resident. The sole criteria for selection will be the academic merit of the candidate. Now comes the condition. Subject to any special orders issued with the concurrence of the Government of India.
Yes.
So my lord had asked specifically that if they come under this, are they entitled to there was a query raised. That is with a connected stipulation that though that will be the sole criteria, that criteria will be subject to any special orders issued with the concurrence of the Government of India.
Yes.
It is their statement or allegation that the central government has not given any concurrence.
Yes.
It is that case. Now let us see. I have handed over on the previous occasion. How much page is scripture? My lord, I have had a bunch of papers for convenience sake, which is already on record, which starts with the writing Annexure 1. That is my letter dated 9th September 2021.
Lordship, it must be already in the record. This is the one.
Which record?
It's a bunch of documents which we submitted on the earlier occasion. It's
Have
page
you got one more set? One
Yes.
more set? Kindly-
Otherwise, it is 138 petition number, page number 142.
If you have one more set, kindly hand over. She will hand over another set if my lord has not got it, or she will. My lord, here's another set for your lordship's kind consideration.
Yes.
Here, and now I deal with category 3, which your lordship wanted me to refer to. I have come to that.
Yes.
Eligibility category 3, candidates belonging to non-local, my lord, B, children of non-local, and children of All India Services Homes of Nagaland cadre. All India Services does not include the army. Under 312 of the Constitution of India, 312, All India Service is specified. Who are the persons who will come under All India Service? IFS, IAS, IPS. They are controlled by All India Service Act rules, Army by Army Act, Air Force Act, Navy Act, all those things, and their separate rules. Anyway, now comes my lord. To be eligible under category 3B, the candidate should have appeared in class 10, 12 or equivalent from any of the schools within Nagaland. Let's stop there. Now here is a candidate. Let's forget domicile for a moment. She has got nothing to do with Nagaland. She didn't appear in any exam. As a state, I am entitled in law to make certain conditions. And the condition I have put is they should have appeared in class 10 and 12. Both these exams she passed, I think, from a reputed school from the capital, I think she passed. Or equivalent from any of the within Nagaland, and a parent should have been residing and posting in Nagaland for at least 3 years or more. I am not pressing much on this domicile business. 3 years or 2 years, that's not the issue. I'll come to the meaning of domicile also, since he has referred to certain Supreme Court judgments. So therefore, I've made these 2 points. Question is, am I entitled to do so? That's the next question. This document of mine, 9th September 2021, which contains all these decisions of mine, my lord, it does not militate against any law.
It does not?
Militate against any law. I'll explain why.
Okay.
So, Lordship, ought to kindly see page 15 of this compilation, 1.5. August 2024. My lord has got that, my lord.
Yes.
I'm only referring to para 2.5, Roman 5. The selection of eligible candidates will be made as per guidelines issued by this ministry's letter of even number dated 12th August 2024. The copy of the merit list together with copies of allotment letters may be sent to this ministry. So this is talking about the guidelines. Lord has got that? No?
Yes.
And if your lordship were to see the petition, the same petition, I think it's petition number 134, my learned additional AG may point out.
Lordship, it's in page, read petition 138, page 7.
7.
Page 7, read petition 138.
Yes.
Yes.
In this para, my lord, they specifically refer to guidelines issued by the central government. This is their petition.
Yes.
They are mentioning about the guidelines.
The guidelines, it starts about
So the guideline is binding.
6th line from the bottom. The allotment of this 42 central seat, has your lordship got it?
Yes.
The allotment of this 42 central pool seats to applicants is governed by the guidelines and direction given by the central ministry, issued annually, while releasing and providing this seat to beneficiary states.
Now, my lord, if my lord were to see, I come back to 13th August 2024, which refers to guidelines, which is binding.
Yes.
Now, in the bunch of documents I've mentioned, kindly turn to page 19, my lord, 19.
Yes,
12th August 2024.
Page 19.
Please, my of my compilation, which has been handed over to your lordships.
Yes.
I may read it, my lord.
Yes, please.
Guidelines for allocation of central seats for academic year regarding the undersigned is directed to refer to the subject mentioned above and to enclose herewith the guidelines to be followed by the beneficiary government department for selection and nomination of candidates against central pool MBBS BDS seats for the academic year 2024-25 for information and necessary action. So here are these guidelines. Next page, page 20, my lord.
Yes.
No, this is a central government document, not my document. It says guideline for selection and nomination of candidates against central pool. Kindly see page 21. My learned friend had also pointed out. The reservation policy being followed by concerned beneficiary state will apply on central pool MBBS and BDS. So, my lord, whatever be my reservation policy, I have not invented this reservation policy. I'm merely complying in letter and spirit to the directions given by the central government. And the method of selection which we are doing, annually this is sent to the central government. And till date, central government has not made any objection to this. I'll come to the Supreme Court judgments. So that feeling that we have done this and we have done that, we have violated this and that, no. They have told us to do it. If they have not told us, we won't do it.
No, you want to say that the requirement in the impugn in the notification dated 9th December 1986,
Well,
any special order issued
correct.
maybe with the concurrence of government
That's the point. That's the point.
is
So therefore,
not
what
required.
I have done, I have accepted this, and my policy, which is there in the letter of 2021, which has been pointed out by my learned friend, that contains all this. So where is my violation?
No, is it your submission that as in the central government notification which you are referring,
Right.
that is 12th August 2024,
My lord.
there is a stipulation at column 1.5 regarding reservation. Therefore, concurrence is not required to be taken.
No, concurrence is if I oppose it. I have accepted. And this has a history. I'm going to tell the history of it. Even before the college in the state was commissioned, established, we were having a separate central pool where we had 100% reservation for ourselves. So there was nothing new. It was not a new introduction. It was following what was there before.
Sorry for the interruption. Just
Please don't interrupt. No, I will not permit it. I never interrupted. That will be very unfair. You spoke for 3 hours.
Yes,
I didn't interfere.
you
Please
reply
don't do it.
afterwards.
Yes. You had enough time? No. Please don't interrupt. I will not allow you to interrupt. Kindly don't do it. No, that's not permissible. I've been fair to you. I did not interrupt. Please don't interrupt.
one has not done.
No, you cannot interrupt like this. My lord, this is
No,
not fair. He cannot do it. He cannot do it. Please sit down.
No,
Please,
Mr.
you are
Jamil,
learned counsel. Please sit down. Please take your seat.
not
I'll
in
be
this
grateful.
manner.
We are doing it. I've never interrupted you. Please
To record.
maintain that. That's all. Please don't do it. Kindly don't do it.
I'm not
You
allowing
stated-
you, Mr. Zamir.
Yeah. Please, kindly.
Take the note and you can reply. I'll give you time to reply.
You can say at that time. If I'm wrong, you
Myself
tell at
taking
that time.
notes.
You get opportunity. Kindly. If I'm wrong, you have a greater opportunity. Please don't do it. Don't do it. No, that's not fair. That's not fair at all. You have been repeating, re-repeating. I didn't object.
It may
You
go
are-
against you if you
I
insist.
never made any comment. I'm grateful. Mr.
Yes.
Mr. Jamil. Please, man. No, my lord.
You take notes and you can reply after he concludes. Not now, not now.
Not now. No, not now. No, not now.
Yes.
Little patience won't harm your thoughts. Now, I forgot where I was. Sorry, I was at 1.5, so we have said that this is the question. I had also mentioned to your lordships that we were having this central pool in which we have the full right to have those seats. So all these things are connected. But my actual point is not on this reservation business.
Yes.
It's eligibility to apply. I'm sorry, her eligibility to apply.
Yes.
In this connection, I'll draw your lordships to a judgment. Where is the judgment? Yes. I'm sorry, ma'am. This is the judgment my learned friend had produced before your lordships. And I've taken out 2 pages from that judgment. The full judgment is before your lordships, what is relevant for me and mean for the case. Kindly hand it over. Where is our point?
14 and 29.
Where is our?
Yes.
Now just bear with me for a minute.
This judgment is relied upon by the petitioner's counsel.
Yes,
also.
that's why I'm throwing light on that. This judgment basically imposes stringent conditions on postgraduate students,
Yes.
particular judgment. But here, I'm only incorporating, I'm not incorporating, relying upon very significant point. And that point refers to the dawn of the Indian Constitution, Dr. Ambedkar. Actually, I have it in the judgment at para 26, but I have just taken a photocopy of that from next page 27. That's the 2 pages which I have given to your lordship. My lord has got the type at the photocopy of 2 pages. She's just handing it over to your lordships.
Para number, page number?
Para number 26. Immediately after 26, the next page.
Just a minute. Yes.
Only one single point I'm going to take out, nothing much. May I read it, my lord? It is the feeling of many persons. My lord is good.
Just a minute. Yes.
It is the feeling of many persons in this house that since we have established a common citizenship throughout India, irrespective of the local jurisdiction of the provinces and the Indian states, it is only a concomitant thing that residents should not be required for holding a particular post in a particular state, because in so far as you make residence a qualification, you are really subtracting from the value of a common citizenship which we have established by this constitution, or which we propose to establish by this constitution. Therefore, in my judgment, the argument that residence should not be a qualification to hold appointments under the state is a perfectly valid and a perfectly sound argument.
Yes.
At the same time, it must be realized that you cannot allow people who are flying from one province to another, from one state to another, as mere birds of passage without any roots, without any connection with that particular province, just to come, apply for posts, and so to say, take the pumps and walk away. That's all I want to say. Therefore, my lord, it is a constitutional philosophy by the father of the Constitution of India, who says, yes, but with reference to these things, as identical as our case, she did not study there. She had nothing to do with it. And she's competing with our brethren tribal students who are no match for them. And if you go by this, what are we doing? The principle is, my lord, even in the Mandal Commission, they say there is only equality among equals, my lord. Very famous title. There is equality only among equals. They further say, to equate unequals is to perpetuate inequality.
Yes.
I'm stressing heavily on Article 14. I'm going to come to I understand what my lord is going to ask me. Before that, I will just complete this question. So you are trying to bring in a system by which, in a tribal state like the state of Nagaland, people who go get a little more marks in that area, which may not be very significant at the national level, they are forced to compete with these people. We have to admit one factor, my lord. And the fact is, because of our various disadvantages, we didn't have many medical colleges. What we have in abundance, we have patients suffering from various diseases, including terminal cases, which are prevalent all over the state of Nagaland. And to get to Delhi with the cost of medical treatment, it is too difficult a situation. So here is a state which has more patients. When you are speaking about the ratio, etc., the number of people who want medical attention is very, very high. I was speaking just in the last hearing, since my lord was not aware of it. We got what is that, CMC Vellore referral hospital in Dimapur. And when this hospital was being conceived, some of the interested parties tried to see that the CMC Vellore does not come into Nagaland. So they filed a writ petition. And when we touched the conscience of the Honorable Court that we are helpless if there is any attack, heart attack or any such heart disease in Nagaland, we are totally helpless. The court, taken into consideration this simple truth, said you can have CMC Vellore. That is how we had a reasonably good hospital in Nagaland. We don't have a multi-speciality hospital in Nagaland. So these are some of our weaknesses. Though he said that I have said so many of these things which are not relevant, they are absolutely relevant because it's for the people of this. The government exists for the people. Government has an obligation to try and do whatever they can. So we are going backwards. So we started in a pit, my lord, by not having a medical institution. And from this institution, if seats are taken away, then we'll be going backward by a year. So they have to answer one limited question: how they become eligible. Keeping reservation, how many days they studied, etc. Are they not entitled to have some link with the schools, education institution in order? So if I had made that condition has not been repelled by the government of India till date. That is why I said that government of India should file affidavit. They have not negatived it. They have not said that this is wrong. Once they have not said that and they refuse to answer, the submission made cannot be thwarted.
So is it your submission that it was issued in concurrence with the government of India?
In the sense that as far as my terms and conditions are there, everything was open. We didn't have anything to concede. Nobody raised any objection. We are a state which gets the benefit from the central government. And whichever seats we have got in the central pool from the beginning till date, that has been approved by the government of India. They have not pointed out any lacuna. This is another issue. They have not pointed out any lacuna. throughout. I can understand they say that we didn't agree to this. How did you do this? Because once we are making the selection process, every file is before them. Nothing is, and nobody objected to this practice. Nobody objected to this. Once the medical college came, we gave our 15%, which we are bound to give. We gave it. As far as the remaining is concerned, which we used to enjoy from before, there they said we want to see there. At least to this extent, they must have some link with the state. They don't have any link with the state. They have so many opportunities of getting their admission in different institutions.
My query is,
my lord,
that the link with the state, the stipulations which you have incorporated in the impugn notification.
Hello.
The central government guidelines provides that you can, by special order, make certain exceptions,
Correct.
but it has to be with the concurrence of the union government.
Very well.
What is there to show that you have taken that concurrence? And what is the procedure to take concurrence?
Well, as far as the concurrence is concerned, whatever I have mentioned in my stipulations, the central government has not pointed a finger at that. That's why they're not coming. That is why I insisted to clarify. Maybe I may not be speaking the truth. Take it that I'm not well informed of it. Even then, they are the persons who can come. So it is not that I go with the letterpad and say, can I do it? No, I've done this. This is to their knowledge. They could have said, no, we won't agree to it. You can't add this. And why they won't create problems in this case is, even in this particular case, here is a person who is an officer from the defense, for whom there are separate, I can understand all roads are blocked for them. No. So if they don't get enough marks at different levels, then they will come poaching upon the seats in Nagaland and take away a seat.
One more query.
Please, madam.
Whether a personnel from defense may be regarded as employee of central government.
Please, madam.
No, that is my query.
Hello.
Whether a defense personnel falls within the category of an employee of central government.
Yes. I have not said no. I have not said no. I only said that as far as this particular case is concerned, defense personnel have got a separate central quota with which Nagaland has got nothing to do with it. They have got 42 seats that were given in different places.
Yes.
I can understand your lordship's query that they don't have any quota.
But apart from that specific separate quota for defense personnel,
Well,
if a person is found eligible under some other quota also,
well,
so to deprive him
well,
from availing the benefit of said quota,
well,
the central government notification says that there may be special orders.
well. May I answer, my lord?
Yes.
Please. Now, as far as that question is concerned, if we take central government separately, in central government, when they are posted, they remain posted for quite some time. They normally will not incur this disqualification which we are talking about. But as far as we are concerned for the moment, we are not dealing with the central government employees in this matter. We are talking about the defense personnel. Maybe the defense personnel is also a central government employee. Maybe. But he is not a civil servant. Generally, when you speak of civil servants, they are people who man the civil services. I am talking specifically of this particular quota, which they're trying to claim. I am saying with respect, there are many other avenues by which they can get admission. They also have a separate 100% quota over which the Nagas are not entitled to even one seat. We are not asking for any benefit from anybody else. We are satisfied with what the central government has given us graciously. They gave us before this college, they gave us after the college. So that method of reservation, they said you apply. Why did they say you apply? Because they knew the rock bottom truth that our students here from Nagaland, they can't compete with the others. They need help, my lord. And when you spoke of merit, this is another significant factor, merit. The lordship were to see this page. I have given 2 pages, my lord. This is Mandal Commission on Merit. Very important. They said so much about merit. 2 pages on merit you have. My learned additional AG must be having.
The Mandal Commission report.
Mandal Commission report.
2 pages.
Which so is there?
Yes.
No, before we go to that one,
Very well.
one small query.
Very well.
Is it your submission that as because 42 seats are exclusively allocated for defense personnel,
Hello.
the present petitioner cannot avail that benefit under any of the 4 categories of mentioned in this order dated 1986 orders?
My submission
He
here.
cannot, as because specific allocation has been made to defense personnel, he cannot take advantage as a central government employee. Is it your submission?
I am going to answer that submission. To add to my answer, I have to read out these 2 pages.
Mandal Commission.
Please. What is merit? Just to understand. What happens when somebody comes from outside and takes away the seat? My lord has got 6.15, my lord. I have the full Mandal Commission report. If your lordship is satisfied, I can mail it also. I've taken what is relevant to meet this particular query.
6.18.
6.15, my lord. Running page 23.
Yes.
24, I don't know. May I read these 2 pages with the lordship's permission, madam?
Yes, please.
In this connection, nothing generates. Lordship, give me a minute, my lord. Your lordship's permission. Please, of course. I'm sorry.
Yes.
I'll read. In this connection, nothing generates so much heat and genuine indignation as the concept of merit, where nobody objects to the grant of special educational facilities and various other concessions to the backward classes, the provision of a reserved quota in educational institutions or services for members of scheduled caste, scheduled tribe and OBCs provoke sharp reaction. The advocate of merit find it very unfair when a depressed class student securing 45% mark gets admission to a medical college in preference to a student from the general quota obtaining 70% marks. This is what they are saying, marks. The resentment is much greater when a lower ranked backward class competitor is selected in preference to a much higher ranked general quota counterpart to an all India service. This is their submission. This sort of reaction is based on two considerations. First, it hurts a person's sense of fair play to see that a more meritorious candidate has been left out in preference to a less meritorious person on purely extraneous ground. Secondly, it is argued by selecting candidates with lower merit against reserved quota vacancies, the nation is being deprived of the services of the best talent that is available to it. This line of argument, though plausible on the force of it, suffers from a serious fallacy regarding the nature of merit. We shall try to illustrate this by a homely example. Mohan comes from a fairly well-off middle-class family and both his parents are well-educated. He attends one of the good public schools in the city which provides a wide range of extracurricular activities. At home, he has a separate room to himself and is assisted in his studies by both the parents. There is a television and a radio set in the house, and his father is also subscribed to a number of magazines. In the choice of his studies and finally his career, he is continuously guided by his parents and his teachers. Most of his friends are of similar background, and he is fully aware of the nature of highly competitive world in which he will have to carve a suitable place for himself. Some of his relatives are fairly influential people, and he can bank on the right sort of recommendations or push at the right moment. On the other hand, Lallu is a village boy, and his backward class parents occupy a low social position in the village caste hierarchy. His father owns a 4-acre plant of agricultural land. Both his parents are illiterate, and his family of 8 lives huddled in a 2-room hut. Whereas a primary school located in his village for his high school, he had to walk a distance of nearly 3 kilometers both ways. Keen on pursuing his studies, he persuaded his parents to send him to an uncle at the Tehsil headquarters. He never received any guidance regarding the course of studies to be followed or the career to be chosen. Most of his friends did not study beyond middle school level. He was never exposed to any stimulating cultural event, and he completed his college education without much encouragement from any quarter. Owing to his rural background, he has a rustic appearance despite his college education. His pronunciation is poor and his manners awkward, and he lacks self-confidence. Assuming that Mohan and Lallu had the same level of intelligence at the time of their birth, it is obvious that owing to vast difference in social, cultural, and environmental factors, the former will beat the latter by lengths in any competitive field. Even if Lallu's intelligence quotient was much higher as compared to Mohan, chances are the former will lag far behind the latter in any competition where selection is made on the basis of merit. Let us suppose that both of them sit for All India Service examinations and Mohan secures 50% marks than Lallu. Does it mean that Mohan's merit is 50% higher than that of Lallu, or that he will be 50% more efficient than the village boy? Is it possible to determine that in view of their respective native intelligence, how these boys would have fared in case they have exchanged places? If merit also includes grit, determination, ability to fight, odds, etc., should not the marks obtained by Mohan and Lallu be suitably modified in view of the privileges enjoyed by the former and the handicaps suffered by the latter? In fact, what we call merit is an elitist society. In an elitist society is an amalgam of native endowments and environmental privileges. Mohan and Lallu are not equals in any fair sense of the term, and it will be unfair to judge them by the same yardstick. The conscience of a civilized society and dictates of social justice demand that merit and equality are not turned into a fetish, and the element of privilege is duly recognized and discounted when unequals are made to run the same race. Only one page left, my lord. I will read that also. Before, my lord has got that, my lord? Second page?
Yes.
Before forthcoming, when he observed, what are called backward classes are nothing else but a collection of certain castes. No, my lord, constitutional provision. Whereas the backward classes looked upon Article 15.4 and 15.6 as a sort of charter of rights. The forward classes and upper classes felt greatly cramped by the provisions of reserved quota in educational institutions and government employment. This greatly hurt their self-interest, and they considered it as denial of equality of opportunity, equality before the law, and a breach of fundamental rights. Consequently, sources of aggrieved parties filed petition before the various high courts and the Supreme Court for enforcement of their alleged fundamental rights, and over the years, a considerable body of case law has grown. It is well known that the development of case law on really important issues seldom follows a smooth curve. If consistency is a virtue of small minds, the judicial mind can never be accused of any smallness. In view of the highly controversial and emotive nature of providing reserved quota for these classes, large number of judgments delivered over the last 2 or 3 decades contain divergent findings on some very vital aspects of this matter. But all the same, taking an overall impression view, one can discern the emergence of some broad conscience on these things. Instead of undertaking an academic exercise of minutely tracing the history and developments of judicial thinking on these articles, Supreme Court judgments which are regarded as landmarks in the evolution of case law on this subject and then to limit some of the important findings which have acquired general importance. It is the Supreme Court's judgment Balaji versus State of Mysore, I had quoted this yesterday, is the most celebrated judicial pronouncement on the question of reservation for these parties, a decisive influence on all that. On the basis of the report of the Gauda Committee of 1962, the Karnataka passed an order reserving 50% seats in all medical and engineering colleges. This was in addition to 15% of seats for scheduled castes and 3% for scheduled tribes. Consequently, 68% of seats in medical colleges were reserved for weaker sections, leaving 32 for the merit pool. This committee had also observed that under the Indian conditions, the only practical method of classifying backward classes was on the basis of caste and community. Further, it subdivided other backward classes into backward, more backward, and chose tributed 50% of their reserve seat. The above order was challenged on the basis of Article 15.4. The first important observation by the court was concept of backwardness is not intended to be relative in the sense any class which are backward in relation to most advanced classes of society should be included in the list of backward classes. Also, backward under 15.4 must be social and educational and not otherwise. Now, my lord, regarding social backwardness, the court observed group of people to whom Article 15.4 applies are described as class of citizens and not caste of citizens. Of course, the Hindu social structure caste played an important part in determining the status of the society. Irrespective of origin, with the passage of time, the functional and occupational base of caste was later ever bounded with considerations of purity based on ritual concepts, and that led to its ramifications which introduced inflexibility and rigidity. In view of this case of groups, whereas caste in relation to Hindus may be a relevant factor in determining social backwardness, it cannot be made the dominant test itself. To determine educational backwardness, state average students population in the last 3 high schools were below the state average. Communities with less than 50% of students were categorized. On this point, the court observed that it is only communities which are well below the state average. Classes whose average was below 50% of state average are educationally class of citizens, marginal verification. The court also felt that the subclassification by the order between backward classes and most backward classes was not justified. In introducing 2 characters of backward classes, what the impute order in substance purports to do is to devise measures for all classes of citizens. So my basic point here is I'll give the full backward class. It's about 340 pages. I can place. What I was trying to say is the merit. When my learned friend said that he was trying to say that we don't have this and we don't have that, these were considered. That you are considering 2 types of people completely at different levels, and now you don't you move, in the words of Dr. Ambedkar, from one state to another, and you take over a state. So what is the effect of this, my lord? The effect of this some student who in the normal course may be expecting that they will be selected. Maybe their name is in the provisional list. One student has to go if this particular student is granted the relief. Now that person who gets the relief will have no avenue to come to the court because by that time the admission and every process will be over. So he gets condemned unheard. And if he gets condemned unheard, just like how the petitioner has been given an opportunity to present her case, this unfortunate boy or girl who's entitled to this benefit will be condemned unheard without even knowing how to contest it. So these are also larger facts which have to be seen in these type of situations. Now, my lord, I also want to draw your lordship's attention to reservation in the Legislative Assembly in Nagaland. We have 60 seats, 601. 59 are reserved for scheduled tribes. Can anybody raise any questions to it? The central government till date has not passed any remark on the eligibility conditions, and they cannot pass any remarks on the reservation because they said we leave it to the state. This is a fact. I can understand a contest from the central government and they disagreeing with all these things and saying, no, this is what this court or that court said, and I can't allow you to do this, I can't allow you to do that. But this was not a new development, the central pool. I have been enjoying it. Nobody questioned. Once I get into with the medical college, I have some seats for myself, then it is questioned. So whether it is a central government employee, whether it's an army officer, I'm answering your lordship's question, my lord, directly.
Yes.
The point for consideration is the state has certain areas to adjust the bolts and nuts in this case. This is a federal state. State is part of the federal setup. We have rights. And I exercise that right as far as eligibility concerns are concerned. So even if domicile is taken away for the moment, can I not introduce a condition that you should have at least studied here? Where? At least in the 10th standard or in the 12th standard. I'm not asking for anything else. They never come over. And the way my lord wants to ask some questions. So the way Dr. Ambedkar has said that would be unfair. So reservation is a separate issue. I am now coming primarily on their eligibility to participate in this. They cannot say that we did not know these were the conditions. Ignorance of law, no excuse, or gazette notifications. So therefore, my lord, in my humble submission, they have overreacted in this case. I don't have anything to say about the candidate because she has a merit and she has also tried in her own way, my lord. I won't make anything adverse on that. It's after all, she's also a student wanting to go up in the academic career. I'm saying, what would it be at the cost of a student from the indigenous tribes of Nagaland? That is the issue. So these decisions which he said, 70%, 80%, and this will not happen and that will not happen, I am not going on that. I am at the threshold asking whether you are eligible to appear in this test. In my respectful submission, my lord, they are not. And more so, till now, central government has not come into the picture. This is an adverse inference. So it's not that they did any harm to me, they supported me. They helped me, central government, from the beginning. So in what way, my lord, I can be put to any type of trouble? Further, my lord.
I have a query.
My lord.
Impugn notification,
My lord.
the next page, para 3, selection, clause E.
I will just. Para 2, my lord.
Para,
Para 2E.
no, not para 2, para 3.
My lord.
Clause E.
My lord.
What is the meaning and purport of this provision?
If seats are available after selecting eligible, number 1. Eligible means they are eligible in every respect. Qualified candidates belonging to recognized indigenous scheduled tribes of Nagaland. Then selection of category.
So if eligible candidates belonging to indigenous scheduled tribe of Nagalands are available, other categories are excluded.
The selection of candidates under category 2 and 3 will be considered. Preference will be given in the following order. Candidates belonging to non-local indigenous inhabitants, children of non-local state government, and children of All India officers home or Nagaland cadre. So this only means this, that if we see the eligibility criteria of the others here, especially the defense people, in this particular case, we have categorically held that they are not qualified to make their application here. So if the seats are complete, I mean, there is excess seats under E, then this will be given in the following: candidates belonging to non-local, indigenous inhabitants, children of non-local, and All India services born on Nagaland cadre. Now, in this, when I have said repeatedly that we were enjoying this facility much prior to 2023, where we were given the same benefits. We were given our seats. So when we were given these seats, it's not that there was a change of mind and that I had to take a special concurrence. I chose a continuity of something which was not my demand, which was offered to me by the central government. So one thing is given to me by the central government, where they gave the full seats. I don't require to do anything more. I accept it, unless I don't want it. Perhaps what is weighing in your lordship's mind is that, is it that only then they will get, or what is the question? The question is very clear. Number 1, you should be eligible to apply. And my eligibility to apply comes from the central government notifications. Those notifications have not been challenged by the petitioner, where the central government gives us the right. Further, the law is, my lord.
Yes.
That suppose central government wants to attack its own circular, it is not permissible under law. That is the law, that government cannot challenge its own notifications. They gave it voluntarily. They didn't say it. Like I've just been informed by my learned friend here of page 21 of writ petition number 134. Page 21, my lord, a letter dated 31st August 2016.
138, petition 138.
Petition 138?
Yeah.
I'm sorry, my lord, this is petition 138. My numberings are wrong, my lord, 138. Page 21, my lord.
Lordship, it's a page 21 in WPC 134. 134. 134.
134. Okay.
21 in WPC 134.
All right. Okay, thank you. My lord has got that, my lord.
Yes. The notification dated to 31 August 2016.
Correct, correct. So I come straight away to parrot 2. Further, the following points may also be kept in mind in this behalf. This is issued by Government of India, Ministry of Health and Family Welfare. The admission of candidates to various colleges will depend upon their fulfilling the eligibility criteria, conditions of admission, and other requirements as laid down by the concerned institution, state government, which may be ascertained from the concerned college. So this is the Government of India letter saying the admission to various colleges will depend on their fulfilling the eligibility criteria, conditions of admissions and other requirements as laid down by the concerned institution of the state government, which may be ascertained from the concerned government. So therefore, my lord, this gives the true spirit of federalism, where the central government is saying that, see, it is your institution, maybe we are financing it a bit, you put your conditions, and whatever are the conditions, you have to abide by it. So this answers many of the questions, madam. It's not.
Okay. You are done with your submissions.
The time is also over, if I'm not mistaken.
Gauhati.
I am sis.
Will not take much time.
Yes. You have half an hour.
I was remembering Delhi, it is 4 o'clock. I forgot.
So I'll leave it to Lordship, if we can continue tomorrow or.
No, let us utilize half an hour today.
If may also wish to reply. If he wish to reply, then we can continue tomorrow. If it's not,
Okay.
just take a short time.
Lordship, I will take a very short time and it is better to finish it today because considering the time, it is running out.
Welcome. Well, up to you.
If I exceed more than the required, then Lordship will stop me also.
Lordship, I have not received any instruction, so I will base my arguments only on the.
Today I have a meeting.
Then Lordship will continue tomorrow.
So, no, I can continue up to 4:30.
Okay.
Before that, Mr. Advocate General, one
My
query.
lord.
What is
My
the
lord.
presently status of the admission? Whether,
I can report that. I'll verify and report it.
yes, Ms. Chokre.
I'll put it in a sealed cover for your lordships. Because since it is not yet declared, whatever information I have, exact question, I'll place it tomorrow. My learned additional AG will place it on record.
Tomorrow.
Tomorrow, I'll place that. I'll place it in a sealed cover for your lordship's consideration. Because normally it is said that until it is published.
It
So,
has.
but since this has a particular query which I am co-conscious of as far as the lordship is concerned, I agree with that. I'll place it on it. I will do that.
Okay.
I'll
Then we'll continue tomorrow. Or Mr. Angarwati, you may utilize half an hour.
Your Lordship had a meeting for then.
Tomorrow as first item, because I'll be fresh. How much time will you take?
I will not take much time.
How much? So that I can plan my. And Mr. Zamir,
15 minutes.
50 or 15?
15.
So let us take it maximum 1 hour. Okay.
Tomorrow, incidentally, my lord, we have the delimitation case likely to be listed, but my learned additional AG is there. In case I am there, she will assist your lordships. In case my matter is coming much later, I will be present. at present. In any other query, I will come and reply to. No problem. Otherwise, she will be there. She is well equipped with the case. I will also try and join it. I don't want to create any hindrance at the moment of the arguments.
Till tomorrow, Lordship, since the matter is deferring to tomorrow, till tomorrow, they should not take Kapan under provisional list.
Pardon?
What? I could not get you.
Because
Till tomorrow?
is already open now.
But
Anytime it may
they
be
have
open.
not published the list. They will be providing.
The status quo be maintained till tomorrow.
No, they will be providing list in a sealed cover to this court.
Report.
Then that's okay.
I was also thinking of this, my lord. Even for 3 days back when I had come to Kohima, I was also trying to inquire and ask them to. They must have done it. I will collect it and my learned edition lady will place it on record and sealed copies.
134 are old and both read petitions. Heard Mr. C.T. Zamir, learned senior counsel assisted by Mr. I.M. Chand,
Yes.
learned counsel for the petitioner. Also heard Mr. K. Balagopal, learned K. N. Balagopal, additional learned
AG.
Advocate General.
And also a list of lawyers who are assisting me, please.
Give the list of counsel. The hearing remained inconclusive. List this matter as part heard matter tomorrow as the first item. Learned Advocate General has submitted on a specific query posed by this court. Learned Advocate General has submitted that the provisional list of the selected candidates have not yet been published. And
Published. The provisional is already published, Lordship, and after that only we have called them for counseling.
After counseling, which list?
We have to have a final list. Final list is not out yet. I'll give the correct position to your lordships.
Final nominated list.
Instead of provisional list, final nominated list has not yet published. He assured this court that a copy of the final nominated list shall be produced before this court tomorrow in a sealed envelope. List this matter as part heard matter tomorrow accordingly.
Lordship, sorry for interruption, but what I've been informed by the official from the department, it says that because of the interim order reserving one seat, the department could not bring out the final nominated list also.
You see, they are going to bring it out, please. I'm going to talk to them. Court wants something, we will do it.
Okay, if there is some difficulty tomorrow, you
No, we will take care of it. I understand it's necessary.
Yes.
I'll place it on. I will inform them.
Would pass appropriate orders
If the petition actually succeed, then the list will change automatically.
If denied,
If the petitioner succeeds,
Yes.
then automatically all the list will be
Change, because what the petitioner is claiming is that she is second topper in the Nagaland list.
yes, therefore it should not be published.
So if we prepare now and if the petitioner succeed, then everything will be jumbled up. For that, they say that I have not prepared.
Whatever is available, my lord, I will talk to the commissioner secretary.
Yes,
I will see whatever is the latest available with us, we'll place it on record.
You have already excluded the petitioner, showing.
We have placed a seat reserved.
Proceed. Accordingly, you can prepare a list accordingly.
Right. No, whatever has been prepared by them as of date
Something
till today,
must have been
I will,
done.
I whatever has been done, I'll place it before this honorable court. That's why I volunteered myself.
Okay.
That's why I'm not letting my additional AG to stop me.
Okay, let this matter be accordingly listed.
For admission, item number 10.
You have to do one thing. These all papers in a separate file, don't mix it. These papers prepare a separate file. Yes,
My lord, if my lord can take up the matter. Won't take too long. At the most 30 minutes, my lord.
30 minutes, I don't have today. We have only 15 minutes time. Today, what is the matter?
The matter is with regard to, my lord, regularization of work church employees, lordship. And the matter is for the posthumous regularization with regard to pensionary benefits only.
Let us fix it on some other day. Indeed.
My lord, if
You can
tomorrow
choose.
we can take it up tomorrow.
How many cases are listed tomorrow?
My lord, since the
You-
matter is item number 10, then we can take it up after the department matter.
Your lordship, let the matter be listed next week.
Next week, my lord, next week I have,
You suggest a date.
my lord, tomorrow we can try tomorrow.
You have difficulty.
No, actually the matter,
Let there be a consensus day.
No,
Both of you
my lord, let's try tomorrow.
tomorrow.
Yes.
Okay. Due to paucity of time, this matter could not be heard today. Let this matter be listed tomorrow.
Next week's item, my lord.
No extra. Tomorrow has fixed items.
Obliged, lordship. For hearing, item number 26.
I believe my learned friend about the government and advocate is meaning. Since it is not like we
Yes.
today. So let it come up tomorrow.
Not tomorrow, next week.
Any of your lordship.
Heard Mr. M.T. Longchar, learned counsel for the petitioner. This matter would not be taken up for hearing due to paucity of time. Let this matter be listed in the next. What is the matter? What is it?
I'm challenging about the certain advertisement about 4th grade posts.
In the next week on a date to be fixed by registry.
Month.
No, date will be fixed by registry.
Month.
I am fixing the week.
Month.
This also keep with that file. Show me that file. For in the chamber.